intra-sentence uniformity versus non-uniformity?
It's a great question. I think Trump wants to argue that because officer and office are different words, they must mean something different. But if you look at Section 3, there's actually a real symmetry there. And the difference comes in different words that are used when you're talking about positions versus individuals. So Section 3 says, no person shall hold a position as a senator or representative in Congress, and people are disqualified if they're insurrectionists who were members of Congress. Now, those two things, I think, clearly mean the same thing, different words for positions and individuals, and so too, any office under the United States and an officer of the United States. And that's exactly what Attorney General Stanberry said in interpreting Section 3, was what is an officer of the United States? Well, we're using that in its most general sense, anyone who holds a federal office.
Well, let me ask two questions, one on that and one on his history. What do we do with the Free Enterprise Fund case where the Chief Justice said people don't vote for officers of the United States?
Well, this is one place where I might agree with Donald Trump, not what he says in this court now, but with what he said in a court in New York, where he said cases like Free Enterprise Fund, they're interpreting the Appointments Clause. And the Appointments Clause says the president appoints all other officers of the United States. And clearly, when you're talking about appointing other officers, you're not talking about the president. And that's usually how the question of officer of the United States comes up in these cases is, are we talking about a mere employee, or are we talking about an appointed officer?
All right, I understand. So let me ask you now the historical question. You referred to the history a few times. Obviously, the first draft of Section 3 included the president and vice president, and that got removed. And my understanding is your position is, yeah, they removed that and broadened the other officers at the end of that. I'm curious if there's any legislative history, quote unquote, to support that.
It's a great question. First of all, that wasn't the first draft of Section 3. Section 3 didn't proceed as like one draft where language was changed over time. There were all sorts of drafts with very different scopes that changed over time. And there's not a clear indication oftentimes of why a particular draft became the predominant draft. But I would also say in the context of that particular proposed amendment to Section 3 by Representative McKee, the original language covered appointed officers of the United States, and it specifically covered the president. Later, Representative McKee offered a different draft, and that draft just said any office of trust or profit under the United States. So it didn't mention the president, it just referred to any office. And Representative McKee, in defending that proposal, he never said, I'm excluding the president. To the contrary, what he said was that this proposal will exclude traitors from all positions of power in the nation, and it will prevent people from voting for any, quote, but those who are loyal. And that is at Congressional Globe, 39th Congress, first session at 2505. And more, I'm sorry.
Please, go ahead.
I was just going to add broadly, one thing the history does make very clear is that by the time we got to the final version of Section 3, everybody, including opponents of the 14th Amendment, knew that people like Jefferson Davis wasn't anymore.
So I was expecting you to follow up with the Johnson-Morrill exchange, right? You get that a lot of play in the briefs. I won't take up time to explain what it is. You understand what I'm referencing. During the congressional debate, there was an exchange that you attribute some significance to, and some scholarly literature from Professor Lash questions that opposing counsel has. Can you respond to their criticism of your emphasis on that one exchange?
Certainly, two things about that exchange, Your Honor. The first is that Reverend E. Johnson took a quick look at the provision and said, why did you exclude the presidency? And I think the thrust of his question was, it would be absurd to exclude the presidency. And I think that's what everybody at the time was thinking, was of course we're going to cover the highest office. And the response by Senator Morrill was, well, it does include the presidency. Look at the phrase, any office under the United States. And then Reverend E. Johnson agreed. And nobody came back later in the debate and said, well, actually, that language is somehow ambiguous.
And so one of the responses has been that acquiescence may have just been out of collegiality, and why are we reading so much into one exchange that might have been nothing more than a nicety?
Well, I mean, certainly that's Trump's argument, but I think that if there were some intent to exclude the presidency from Section 3, given how important that would be, I mean, think about that. You'd be saying that a rebel who took up arms against the government couldn't be a county sheriff, but could be the president. You'd be saying that would be a really big thing. And you'd think we would see some indication in the history of somebody coming back and saying, no, we're carving this out because it's somehow different. And there's just no indication of that at all.
Right. I guess I just struggle with how much significance we should attribute to the McKee draft or the Johnson-Morrill exchange. These things seem to be sort of conveniently plucked. I'm not sure how instructive they ultimately are in the grand scheme of things.
I think there's always a question of how instructive legislative history is, and I think here, where the text is so clear, and where the consequences of saying that the presidency is not an office under the United States would be so bizarre, because you'd be saying that, for example, in Article 6, Congress can impose a religious test for no office except the presidency, and I guess you could require the president to be a Jehovah's Witness, or that no office under the United States, the holder of them can accept bribes from foreign kings or princes under the Emoluments Clause, but that because the presidency is not an office under the United States, the president can go to a foreign prince and ask them for a title of nobility. And that those results are just so counterintuitive to our constitutional structure that a careful parsing of legislative history here, I think, is interesting, but really not terribly necessary.
But if it was so important that the president be included, I come back to the question, why not spell it out? Why not include president and vice president the way you spell out, they spelled out senator or representative?
Well, I guess I go back to the kitchen sink approach, right? They used a really broad phrase, any office under, and then they wanted to include the handful of things that may not fall in that catch-all. I think everybody knew that the presidency was an office under, and along those lines, I just direct the court's attention to about a dozen sources from speeches and newspapers that we've cited in our brief. Both supporters and opponents of Section 3 had no difficulty understanding this, including opponents. So Exhibit AD of our brief, we cite an example of a rather racist opponent of the 14th Amendment who was saying it was kind of deeply unfair in his mind that black Americans like Frederick Douglass could be president, but no person under a disability of Section 3 could. It wasn't just radical Republicans saying this. Everybody at the time knew Jefferson Davis couldn't be president and that any office included the president's.
So to oversimplify, or perhaps oversimplify, your reading of Section 3 really is members of Congress who are not officers, electors who are not officers, and then all officers.
That's exactly right. That is our reading, Justice Gabriel. And I see that my 20 minutes has expired. Thank you.
All right. Mr. Olson, when you're ready.
Thank you very much, Mr. Chief Justice, and may it please the court. Trump levies two types of complaints against the finding below, but neither should disturb the district court's holding that Trump engaged in insurrection against the Constitution. First, he complains that the district court's finding that he engaged in insurrection was unsupported by the facts. But he ignores the worst facts that make clear the district court was correct to find that Trump gathered, summoned, and incited a violent mob that stopped the constitutional transfer of power on January 6th.
Mr. Olson, I'm going to stop you there because I think, was the district court in a position to make those findings? That is, did the district court have jurisdiction? Is a pretty fundamental question here.
Yes, the district court did have jurisdiction, and I can walk you through exactly how we get there. Article 2 of the Constitution gives states great latitude in how they select presidential candidates. Under that latitude, Colorado has enacted an election code that gives district courts, including specifically in presidential primary elections like we have here, the authority to conduct the qualification disputes like we had here. So yes, the district court had jurisdiction using the authority that the Constitution gives Colorado, and Colorado unlike many other states, has chosen to implement that authority with this pre-election challenge under Section 11113, which Section 1204 incorporates specifically, which allows for electors, voters to challenge a wrongful act or about to commit a wrongful act by the secretary. And as testimony at the hearing from Ms. Hillary Rudy indicated, the way in which that plays out in Colorado under that statutory scheme is that the secretary makes initial determinations that are easily determined, and then following this court's decision in Kuhn and Frazier, additional evidence can be brought to bear in Section 11113 proceedings that allow for the qualification dispute to be resolved.
So, if I'm understanding that argument, this itself, or herself in this case, could not conduct an evaluation of the constitutional qualifications of someone to go on the ballot.
No, I would disagree with that. The testimony of the practice, which was consistent, is we have the Hassan case from a few years ago, where a presidential candidate said, I am not a natural-born citizen as that is currently defined. I therefore cannot sign the attestation that's required that says I meet all qualifications. In that circumstance, the secretary sent a letter and said it is my job to make sure that only qualified people are on the ballot in Hassan. Because you are constitutionally not qualified, you're not on the ballot. Hassan then sued, and then Judge Gorsuch on the 10th Circuit affirmed the secretary's authority and decision. Now, that was under federal law, not the 1113 procedure.
And it was 2 paragraphs and not exactly a deep dive on our election code. Wouldn't you agree?
I would agree, but the core principle was not in dispute and animates the way in which our election code works to basically allow for process to occur. So it isn't just the secretary making this decision of hard to find. But as this court recognized in Frazier, even simple questions like residency can be really hard to figure out sometimes and require a lot of evidence and
But here's my concern. The secretary's duties under the provisions that govern presidential primaries very clearly are limited to making sure that a presidential primary candidate is a bona fide candidate under party rules and has timely submitted a certificate of intent. That certificate of intent includes the Article 2 affirmative qualifications of age, residency, and citizenship. That's it. And in the Hassan case, as you pointed out, the candidate was unable to comply with that. So there's a very clear duty expressed in 1204 or 1, actually, saying that the secretary cannot certify such a candidate. Where is the duty here to examine other constitutional qualifications, or are you instead relying on the wrongful act language to support your petition under 113?
So let me point to 3 authorities that may help us resolve this question and your concern, Justice Marquez. The first is that Section 14121, which is the presidential primary part of the election code, says that the purpose is, the intent of the people is to conform to the requirements of federal law.
Federal law governing the conducting of presidential primary elections.
I don't think it's so limited. I think it's more general. I think that it is federal law, which includes constitutional requirements. Second, I would point to 1412033, which says that presidential primary elections must be conducted in the same manner as any other primary election, which brings in 14501, which is sort of the general qualifications clause for state candidates, which certainly empowers courts to look at it.
Can I interrupt you right there? I believe your reliance on 501 actually undercuts your argument for a couple of reasons. One, the sort of boilerplate about election officials must conduct primary elections consistent with general elections. That is boilerplate that appears elsewhere in the code. And so I don't know that it has a whole lot of magic to it. It doesn't expressly incorporate And more importantly, 501 is limited to state offices. So how is that connected in any way to establishing constitutional qualifications for a presidential candidate?
Two ways, Your Honor. First is so Section 14501 is in the state candidate section of the code. When the presidential primary section, which was passed recently, says presidential primaries for they do all these other primaries, our position is that that brings in the process of 14501, but doesn't include the limitation in 14501 because it would be silly to read that as only applying to state candidates. And the second is that Ms. Rudy's testimony at trial was that these qualifications, constitutional qualifications, aren't just the three checkboxes. It says on the bottom of the form, attestation that you meet all qualifications. Section 3 is a qualification in the Constitution that someone must check that they meet. And if the Secretary certifies someone under that authority that doesn't meet all qualifications, that is a wrongful act. And that is a wrongful act that we challenge here in 1113. I hope that addressed your question.
Mr. Olson, I want to hear that you never finished the start of your answer, and I'd like to hear all of it. You said there are 3 statutory provisions you're relying on. Could you please finish that answer?
Yes. So the third statutory provision is 1412032A, which talks about political parties putting a, quote, qualified candidate on the ballot. That section is directed to parties, but it requires that for a party to put a candidate on the ballot, it has to be a, quote, qualified candidate. And it is passing strange from our perspective to say that where the goal is to conform to the requirements of federal law, that we have a robust system to allow for challenges to candidate qualifications of all types. To exclude one particular qualification because it occurred in the Constitution, our most important document, rather than somewhere else.
So I'm just wondering if you can respond to the arguments made in part at the end of Professor Mueller's amicus brief, in which, for example, in looking at 1201, he talks about how the phrase governing presidential primary elections, as Justice Marcus has suggested, seems to modify both national political party rules and the requirement that Part 12 conform to the requirements of federal law. So if that's the case, does that matter from your perspective, if it does?
Well, I certainly think this court's pronouncement on how ballot qualification challenges occur in Colorado is more compelling than Professor Mueller's account. Because think of the consequences of that proposal, which is we have a system where qualification disputes occur in, as this court is well aware, nearly every election cycle, where all sorts of issues are raised. But we are cutting out a class of qualifications that are important for our most important office and saying state courts can't look at those.
Do you agree that the phrase modifies conform to the right requirements of federal law?
No, I think I disagree with that. I think it's...
And why do you disagree? Because he points to, oh God, I'm going to actually say this, post-positive modifiers, right? And how that seemed to be an example of that. And he cites this Scalia Garner text on reading law. Why is that mode of analysis wrong? Because it does seem to apply here, that phrase.
Well, I'm afraid that I'm not as well versed in the descriptions of the various theories of interpretation, and I would focus on 2 things, just as in response. One is what I just said, which is just like in the office officer discussion you had with my colleague, it seems absurd to not allow these kind of qualification events to occur when they're an essential part of what we do, and the Constitution gives Colorado, through Article 2, such authority in figuring out how to run their elections.
Well, see, I wonder whether the question might be that it becomes a question of whether Section 3 constitutes a requirement of federal law governing presidential primary elections, and if the answer is yes, even adopting his construction, if the answer to that is yes, then the people of the state of Colorado are saying they want to see conformity with Section 3. So, I'm wondering whether the construction that he's urging is really detrimental to your case in the final analysis.
Well, it may or may not be that the National Party in this case has said they can nominate an unqualified candidate. And if they have the legal authority to do that, we don't think they do, then it would be a challenge for our case if the National Party rule said you can put an unqualified candidate on the ballot. We don't believe that's the case, but under their interpretation, it would be a challenge. But we think the more natural reading is that when you say conform to the requirements of federal law, that
governing presidential primary elections, right? If we were to take the party rules component out of there and just say that those other two phrases are tethered to one another, then does it really matter? And
in that circumstance, no. So if that was your earlier question, I apologize.
That's what I was trying to say. I probably didn't say it very well.
So I don't think it matters, but again, we come back to sort of the common sense reading of our state statute of how we do this, which is to allow courts, like the district court did here, to hear the qualification disputes, even under federal law.
Well, let me ask you about that, Mr. Olson. Good afternoon to you. I'd ask you to address the intervener's argument here, and I guess this goes to prudential concerns under justiciability. You say that all the state's election officials, state secretary authority to decide how to run primaries. They take the position that that could create chaos. You could have 50 different states attorneys, states secretaries of state deciding differently, and this really needs to be national. I take that as fitting within the prudential concerns under justiciability. Can I ask you to respond to their argument?
Sure, Justice Gabriel. I think I would say three things in response. The first is most secretaries of state don't have the authority to evaluate qualifications, even the way in which Colorado does, for primary elections. We saw that in the Michigan and Minnesota cases where they said their state laws, their execution of their Article II authority allows purely ministerial. They take the piece of paper from the party and they put that person on the ballot for the primary. Here we have a different rule, and so that leads to my second point, which is it won't lead to chaos. This is the only court in the country that has looked at this question. There are other courts where lawsuits have been filed, but as I mentioned, those lawsuits haven't proceeded, so different courts do it differently. Colorado has done it this way, and we have an opinion that's on appeal before this court. And so I think the concern of a bunch of things happening is overblown. And the third thing I would say is that the legal standards here that really matter, what does engaged in mean, what's an insurrection, et cetera, will be figured out pretty quickly if there are different approaches to that. And the answer in these ballot access dispute cases are binary. It's not that there's going to be a whole bunch of different standards floating around. It's going to be either yes or no. And so I think the concern of overblown, the concern of a patchwork is overblown, particularly when, the justiciability inquiry looks at, is there a textual commitment to a coordinate branch of government?
Well, let me jump in for a second. I mean, that's under, if you're looking at sort of the political piece of it, right? And you're looking at basic other more prudential concerns, and perhaps that's what Gabriel was asking about, and perhaps not. But can you sort of parse that out?
Sure, I would say.
So political question doctrine versus sort of broader, more general, of the type perhaps talked about in Powell.
Yeah. So I would say two things in response, Justice Birkencotter. And the first is that just because this is a politically salient question and has political consequences is the reason for the court to enforce our constitutional qualification, to honor the promise that we made to each other in our document, and say to engage in insurrection, no matter how are not to, having broken an oath engaging in insurrection, are not to be allowed in that position again. And so the second is that there are very easily manageable standards here, as I just mentioned. This is not a case where courts having to put themselves, balancing foreign policy interests and all sorts of interests that are assigned to a different branch of government. This is a straightforward application of our Constitution.
So, but even if I'm persuaded on prong 1 and prong 2 of Baker, which is really what you're talking about, isn't there this other sort of prudential concern? And that goes to this idea of if you have, whether it's 50 states or 30 states or 17 states, you're going to have chaos. Can you talk more specifically about that?
So I would come back to my answer to Justice Gabriel, that the way the state laws are implemented on this issue under the Article 2 authority, that there simply aren't going to be very many other proceedings like this, because Colorado has chosen to implement this in a unique way. But even if there are, that's okay.
How many of these cases are there altogether?
Well,
Of this sort of general type?
well, there are a number of general types, but a number of them are filed by the same individual who marches into federal court. There's clearly no standing in federal court to bring these claims. So of the cases where people were prepared to actually put on evidence, there's just a handful. And this is the only one that has proceeded to the merits.
So, Mr. Olson, should we be concerned about that as we think about the Republican citizens of Colorado or unaffiliated folks who want to cast a ballot in the Republican primary? If what you're saying is correct, President Trump will be on the ballot in most states, but not here in Colorado. So effectively, the Republican or unaffiliated voter who wants to participate in the presidential primary, Republican primary, won't really be able to participate because the person who's on most ballots and appears to be leading in the primary is not an option.
But Justice Hart, I think I would say two things in response. The first is other states have different mechanisms. California allows for post-election challenges when there's an unqualified candidate on the ballot. So just because there's not a pre-election qualification dispute under state law doesn't mean there won't be a post-election one. And then secondly, Donald Trump is disqualified for the reasons that the district court found, with the one mistake of whether it applies to him. And that determination will allow for voters in Colorado to vote for qualified candidates. I would say that your hypothetical actually cuts the other way, which is we're worried about our clients who are Republicans and independents. They filed this suit because they want a fair shot in the Republican primary to vote for a qualified candidate and have their support for a qualified candidate not be diluted through votes for a candidate who will subsequently be disqualified. And so the pro-democracy, sort of the pro-Colorado voter perspective, which is I think what we're looking at here, is to make sure that we follow the state law and allow for these qualification decisions to occur pre-election so that the ballot reflects those who are qualified and the will of the voter can be honored.
So I just wanted to take you back. Your repeated reference to qualified candidate makes me think of your third item under 141203 sub 2A, where it talks, the election code talks about qualified candidate entitled to participate in the presidential primary election, and then it ends with pursuant to this section. And I'm just wondering, from your perspective, what work, if any, pursuant to this section is doing in that sentence. Again, not to place undue significance on Professor Mueller's amicus brief, but you can remember that he suggested that that's limiting. Although as I look at 1203, it doesn't seem that there are other qualification provisions in there. We have to go to 1204 for some of that. So I'm not sure what to make of pursuant to this section.
Well, so I would read pursuant to this section as referring to sort of when and how the primary election is conducted. And the pursuant to this section says, if you have a qualified candidate, then you can be on the ballot when they're going to do it the way they say they're going to do it.
Simple as that.
Yeah, that's our view there. And I think, but the qualified candidate isn't limited, right? It is a qualified candidate. And so
I'm sorry, as you recognize, so that provision is really about the party's right to participate in the primary. And let's say a major party had multiple candidates, 3, say, one of which ends up being disqualified. The party could still, nevertheless, under this provision, participate in the primary.
Correct, because it is, as Your Honor focuses on, it is directed towards the party itself, but it requires that there be a qualified candidate as a necessary precondition of participation. And to me, it's I'm sorry to cut you off.
I'm sorry. My sense is you're placing an enormous amount of weight on that single reference to qualified candidate in a provision that is not tethered to specific duties of the secretary. And I'm going to circle you back to 501 for just a moment, because by contrast, in 501, there is very rich language about the secretary's duties for state office. No person is eligible to be a candidate for office unless that person fully meets the qualifications of that office as stated in the Constitution and statutes of the state. If we had that language somewhere in 1204, I think we'd be having a very different conversation. But it's not there, and I'm still very concerned about how much you're trying to cram into the word qualified candidate.
So we're not solely relying on the qualified candidate language. We're talking about the general function of Part 12, which says, again, as we talked about in 1201, the goal is to conform to federal law. Then we have 12033 that says the same manner as any other primary election. Now, we believe that that incorporates that same 14501 language, and the language you identified in 14501
refers to Constitution and statutes of this state.
Correct. But again, that limitation, when you look at the history of how the presidential primary in Colorado came to be in 2017, it just, our view is it pretty clearly just bolted on a process for the presidential primary that carved out, as we talked about Justice Hood, where the national party plays a role in a way that's different for state offices. But said, here are the specific changes that we're going to do, and everything else we're going to do the way we've been doing it. We incorporate, to the, in 12033, do it the same way we do all these other elections. And it would be, in our view, quite astonishing to have a state election code that didn't allow for even basic efforts to see whether the candidate for president is qualified, where you have someone who's, Hassan would come out the different way, because the answer there, under the interpretation where it's only state law qualification and reference, would be, hey, you're not qualified, but under state law we put you on.
Hassan would not come out the other way, because the duty has the secretary has an express duty under 12041 to make sure that the person timely submits a certificate of intent, and Hassan did not submit such a statement.
Well, but it would.
We've got lots of other things to argue, and I don't need to drag you.
We got to get through this one together. So, so what I would say is that what we have in this case, Trump has submitted a declaration to the secretary where he has certified that he meets all qualifications to be on the ballot. And this is no different than Kuhn, where the paper said yes, but then our 11113 procedure, which is expressly adopted in Part 12 of the Election Code, allows for the court to consider additional evidence. You don't have to take the candidate's word for it.
Is that certified though? I'm sorry.
Go ahead. Go ahead.
No, Chief, please.
Well, let me ask a fundamental question, and maybe this is too basic, but could the Secretary of State at the very beginning of this, before the lawsuit was filed, said, President Trump doesn't meet the qualifications under the federal Constitution?
The secretary, so maybe is the answer. The reason why I hesitate.
Well, then, okay, go ahead. Finish your answer.
Because the secretary testified that their practice has been where they know of disqualifying information or can readily ascertain it, they will disqualify a candidate. But where there's uncertainty, they will not, and allow for the 11113 process to play forward. There are no funds, there's no investigative division of the Secretary of State's office that runs around and looks at this. And so on these sort of harder questions, be they residency, what have you, the Secretary turns to the courts, and this court has recognized over and over again that that's the proper procedure for courts to make these hard questions.
Okay, but why is that? It feels like 1113 is designed to say, Secretary of State, do your job, plain and simple, right? I mean, is that too much of a simplification of that?
No, I mean, it's if you don't do your job, people can can bring you to court and make you do your job.
Or if there's a concern that she's going to violate a duty, an elector can bring her to court.
Yes.
Right, but do your job. So why does the court then have more authority than the secretary make that?
Because that's the way that this court, particularly in Kuhn, has interpreted our in the 1-1.
But we said we wouldn't consider a constitution in Kuhn, right?
No.
What, is that, do we have to overrule that?
No, not at all. In Kuhn, there was a separate constitutional cause of action. All we are seeking here is to enforce the election code under 11113. So it is not a question of, and just like in Hassan, where the qualification issue is a constitutional one, and particularly for federal offices, right, those constitutional qualifications are by definition not set by the state, they're set by our federal constitution under U.S. term limits, that is what they are. And so those proceedings occur under 113, and in Kuhn, and as the Secretary's brief in this case, where a constitutional issue is the qualification, you can't in a 113, not that there are prohibition,
Position basically this information. To take that action.
That would not be for public purpose or public ends under this definition. It really requires, as we saw here, and as the testimony of stopping the counting of the electoral votes is hindering the execution of the Constitution.
The distinction then is that there's an attack on the authority of the government, even if it's not an effort necessarily to overthrow the government. Is that what I hear you saying?
Yes, because an effort here to delay, use violence to delay the count would be an insurrection.
And I don't even want to save time, but just very summarily, do you see much distance, if any, between the argument that you're making that the district court adopted and the argument that is set forth in the Bode-Paulson article? Is that, I mean, they use slightly different words, but they seem to sort of deliver a very similar message in my estimation. Is that fair?
That is fair, but I think what is crystal clear is that what happened on January 6th easily satisfies either definition.
So let's not get lost in the weeds on the test.
Let's not get lost in the weeds. And I do want to save time for about, I want to make sure I answer the court's questions as well, but if I could end on a final comment and then come back for rebuttal, which is that our Constitution, as we talked about, is just a document. It's a promise to each other that we must enforce to protect our shared democracy. In committing ourselves to that Constitution, the rule of law comes with real fragility. Because our Constitution commands no armies, has no police force. All it has is very limited self-defense mechanisms that my colleague mentioned, and that is Section 3. And all Section 3 says that if you take an oath to support the Constitution, and then turn around and attack the Constitution, you cannot be trusted to take an oath a second time because you've shown yourself unworthy and incapable of ensuring that we remain a nation ruled by law rather than by one man. Qualifications, by their very definition, limit who can vote or who can run for office. And Trump's argument that because he's popular, that should affect how we interpret Section 3 here could not be more dangerous. Jefferson Davis would have gotten a lot of popular support right after the Civil War. And the application of Section 3 is at its most urgent when a person who has desecrated their oath to the Constitution already seeks to become our commander-in-chief again. If we say that this conduct by this person is not enough under the Constitution, what we do is empower Trump and others to use more political violence to attack our democracy. Enforcing our Constitution enables the will of the people, and we must enforce it against unlikely candidates like Hassan in popular candidates like Trump. I'd reserve the rest of my time for rebuttal, but we ask that you reverse the district court's finding that Section 3 does not apply to Trump and affirm in all other respects.
Mr. Olson, before you sit, I have a question. The grounds for disqualification here obviously have to do with Section 3. And I worry about the fact that Section 3 itself doesn't have an enforcement mechanism. And so here you're saying, well, Colorado state law allows us to enforce it in a way. And you said California has a system. Do we want an approach where each state decides on their own what Section 3 means or how it should apply? And then those states that don't have a law like Colorado are not able to do anything about it? I worry about that. Can you address that concern?
Sure, Justice Moore. I would build on my answer, I think, to Justice Birkencotter earlier. And if I may have a couple minutes for rebuttal, even if it takes a little longer, Justice Boatwright. I think I'd focus on two things, which is particularly for the presidency, where Article 2 gives sweeping authority, as the Supreme Court just said in Shuffalo and Baca a couple of years ago, for states to determine how to do it. There is going to be some uncertainty. Some states used to use legislators to pick their presidential electors instead of a popular vote. So some uncertainty is built into the system. And then I would say the second piece is that the legal standards that apply here under the Supremacy Clause, or what engaged insurrection means, will be uniform. It may take a little bit to get there, but there is a mechanism to ensure that uniformity. And so there's no need to worry that there's going to be 50 different approaches to this issue. There's going to be one approach here. Maybe another state will do it, maybe they won't. But there's not an overwhelming indication that there's going to be 50 different approaches here. And the last thing I would say is, even if that was the case, that's the nature of a federal system like we have. The states have broad authority, particularly where there's a specific allocation of responsibility under the Constitution. In our existing mechanisms, the courts, the Congress, the U.S. Supreme Court have shown their ability to keep those concerns from overwhelming the issue. So that's what I would say to that question.
You may reserve the remainder of your time.
Thank you.
Thank you, Mr. Olson. Mr. Gessler, when you're ready. That was a very steady pour. Impressive.
I'm going to need that water, I think, Your Honor. Members of the court, thank you very much for your attention here today. Again, my name is Scott Gessler, representing President Trump in this matter. Time permitting, this is a big case. I'll try to talk about why this court should not exercise jurisdiction under 113 and 1204 under the principles set forth in Frazier versus Williams and Kuhn versus Williams. I'd like to talk about the textual structure, the officer of the United States, the office under the United States, and the oath, the textual structure. And time permitting, I'd like to talk about the issue, the legal standard of engagement, and of course insurrection as well that have been asked, and then perhaps get to the infirmities of the court using the January 6th report. I know there's a lot. Please feel free to interrupt me and move from one section as members of the court see fit.
Just before you dive in, I did not hear political question doctrine on that list, so.
I put that under the category of enforcement.
Okay.
Broader federal enforcement. So we sort of view, when you talk about self-execution, preemption, political question, they are sort of intertwined with some of the same considerations, in part because of the difficulties of applying consistent standards, which ties into the fact that Section 5 of the 14th Amendment creates a specific enforcement authority to Congress, which was recognized in the Griffin's case here. So that does sort of talk about the justiciability. I can dive into that section if
Let's
you want
start
right
there.
now. I'm sorry?
Let's start there.
Okay. Your Honor, so enforcement is the proper framework, and this is a non-justiciable question, and there are prudential concerns that 3,000 different state jurisdictions will approach this in different ways. Now, I understand that the petitioners have said, well, that's okay, under Article 2 powers, states can do whatever they want. Well, that's not true. States can't do whatever they want under the Article 2 powers. There are still nonetheless constitutional mandates. For example, in petitions, states have to behave a certain way, as in Anderson versus Celebrezzi, for presidential candidates. And in fact, in Anderson versus Celebrezzi, the court said that the state interests are lessened when it comes to a presidential candidate. An invocation of Article 2 powers to choose presidential electors, that's not an enforcement mechanism in the sense of a judicial enforcement following the law. It's a political process, and it's a value decision. The people of the state of Colorado could, for example, if they amended Section 20 of the Schedule Constitution, that requires allocation of electors by popular vote. But if they amended that, they could say, we don't want anyone with gray hair. We don't want anyone over 5'2". Okay? They can create those through political value decisions. That's not an enforcement mechanism of Section 3.
Well, let me just ask you directly about that to go right to the point. Obviously, you focus on Section 5, and it says, it gives authority to Congress to enforce the 14th Amendment. It doesn't say exclusive authority, but my concern is this. If we have to rely on that as the enforcement mechanism and the 14th Amendment is not self-executing, then the Due Process Clause and the Equal Protection Clause are not self-executing. So Congress could nullify both of those by doing nothing and taking no action. That's concerning. The 13th Amendment has the same language. I don't think anyone would say that Congress needs to act to enforce the abolition of slavery. So help me understand how do we get to self-executing here?
So I think Justice Chase would disagree with that characterization with respect to the consequences. In the Griffin's case, which I think was discussed at length in Professor Tillman's amicus brief, Justice Chase basically created sort of the sword versus shield distinction, that in the Jefferson Davis case. And in the Griffin's case, he said that, I think he did use the word executing, that the Section 3 does not execute itself. In fact, it requires implementing legislation. Now, that was from a Chief Justice of the U.S. Supreme Court. I recognize he was riding circuit in Virginia. But Congress then almost immediately did what he suggested or what he demanded to be done. In other words, it passed the Enforcement Act. That's consistent.
Sorry to interrupt, Mr. Gessler. To come back, I guess, to Justice Gabriel's question, the fact that Congress passed one form of enforcement legislation doesn't mean that there might not be other ways that that Section 3 comes into play. They didn't cover the field.
Well, that's fair standing on its own. But in response, we still have Justice Chase's decision in the Griffin's case. And remember, Justice Chase took a very muscular view of use of the 14th Amendment. He dissented in the slaughterhouse cases and specifically decried the limitation of the privileges and immunities portion of Amendment 14. So, but when you look at Section 5 of the 14th Amendment, why do we even need that? Well, Congress thought we needed it. Congress thought the framers thought we needed it. They thought they needed it in order to grant Congress that authority. They didn't grant the states authority. Now, one can say, well, that means nothing. But actually, if you look at the 14th Amendment, the whole purpose of the 14th Amendment was to limit states' authority. It would be very counterintuitive otherwise. Yes, ma'am.
Yeah, so can you point us, though, to sort of that, the textually demonstrative constitutional commitment? I think, as I understand your argument, you're sort of asking us to look at the gestalt, right? You want us to look at the whole, these four separate parts of the Constitution, and sort of stitch them together and say, look at that in terms of this first prong of Baker. And is that correct? Can you point me to something specific?
So with respect to the four prongs of the Constitution, you're referring to?
Your argument with respect to how this is, how we are foreclosed under the political question doctrine. Sorry, I'm pivoting around here.
No problem. Well, I think there's a couple reasons. One is the prudential reason that had been discussed, which is a multiplicity of different states. The petitioners mentioned that California is a post-election opportunity for attack. So that may be one way. New Hampshire has said that despite the Hassan case, they have the exact same situation as in Colorado. They don't have the authority. So you do have a patchwork where voters are going to be treated differently and affected across the country. And that is somewhat chaotic.
Isn't part of the answer to that if we were to say that President Trump can't be on the ballot here, there's a very high probability that the United States Supreme Court would step in and decide what the standards should be, one would think, so there wouldn't be the same potential for the chaos that you're describing. Is that not a fair response?
Well, President Trump would certainly think that, yes, we would want to appeal it. But I don't think that the court should rely upon the hope that the U.S. Supreme Court will step in. The standard is we should look at that in advance and prevent that bad situation from occurring in the first place. Those are the prudential concerns.
Well, let me pick up on, and really the point you made, which was we have this today. We haven't had chaos in well over 200 years. I mean, states have these authorities. California has one mechanism, New Hampshire has a different one. I'm not so sure that we have the crisis that you might suggest.
Those mechanisms are procedures. They're not the substantive application of Section 3. There is a difference there. When we talk about procedures, yes, New Hampshire has a different set of laws for qualification than Colorado. But those are all different procedures. They're not the substantive application of a disqualification standard.
Forgive me, Mr. Justice, let me ask you about that. So can the Secretary of State disqualify a candidate who is not born in the United States?
That's a question. I don't think there's a statutory authority for them to do that. Now the petitioner has said, well, Hillary Rudy testified to this and that, and deep respect for her, but that doesn't define what a state's authority is. We have 1204, which requires a statement of intent. And the question is the form for 1204, does that carry the force of law? That's really sort of the question.
Well, it's a constitutional qualification. That's why I was asking the question. I mean, there's some suggestion that we should look at different qualifications differently. The 35-year age limit and the born in the United States are one thing, but the 14th Amendment is something different. That's what I was asking.
Right. First of all, I'd say the 14th Amendment is not a qualification. It is a disqualification. And in fact, if we even look back to McKee's original introduction of that legislation, that talked about qualification and holding, whereas Section 3 only talks about holding. So I would probably not concede the point on qualifications.
So actually, to that, and I know we're going back and forth between political question and I suppose the question of whether Section 3 is self-executing. But as you say, it's a disqualification. The only thing that the 14th Amendment says that Congress can do is remove the disqualification. Doesn't that suggest that the disqualification attaches independent of any act of Congress? Otherwise, they'd have nothing to remove. Did they have to say that Jefferson Davis met the definition of an insurrectionist under the 14th Amendment?
I would disagree that Section 3, that last clause, can't be read in isolation from Section 5 enabling legislation. And the Section 3 congressional action is more akin to the powers of a presidential pardon. It's essentially a pardon mechanism. And I don't think one can draw the inference that forecloses or affects the substantive law that allows that disability to come into effect. You look quizzical, Your Honor.
I am in fact quizzical. Go ahead.
Justice Gabriel, where are you going? So you mentioned these prudential considerations, and let's avoid chaos. One of the counter arguments is that by failing to resolve this issue on the merits now, we create the potential for chaos in January of 2025. And so there's much emphasis on this in the scholarly literature about how it may be better for us to try to resolve it sooner rather than leave the potential for a constitutional crisis after the next presidential election. What's your response to that?
The response is not if we follow what I call the rule of democracy, what Attorney General Stanbury said in a couple instances, that when there's uncertainty, the disqualification doesn't apply. Ultimately, if the Republican Party chooses to take that risk, and Republican and unaffiliated voters in the state of Colorado choose to make that choice, that is their choice. It should not be foreclosed from this court.
Well, what do we do about Timmons then? What do we do about Timmons, where the U.S. Supreme Court says there's no absolute right to put someone who's not qualified on the ballot?
I would.
And we're talking about a political party here.
Right. And I agree that there aren't absolute rights, but there's certainly a minimum an ambiguity here. We don't think so on with respect to our approach. But the Timmons and the Wisconsin ex rel Follett cases nonetheless stand for political party First Amendment rights. That even if state law, for example, in the Wisconsin case, even if state law mandates one thing on how to assign delegates, state party rules prevail.
So your view is, and I would take it, that if either party wants to put on, we'll say, President Obama, or someone who's 20 years old, or Arnold Schwarzenegger, they have every right to do that.
Conceivably, yes. Now,
Wait, you're saying conceivably, what do you mean conceivably?
well,
They or don't they?
and I was about to go for it. Look, I mean, Hillary Rudy testified, and it's not unreasonable, her testimony, and she said, look, the secretary can be involved in using the form for the 3 Article 2 qualifications, if it's an objective, knowable fact.
So then if it's a fact question, the secretary can't. So if there's a question about whether the person was born in this, was or was not born in this country, the secretary can't act. But if it's objectively, nobody doubts it, then the secretary can. That's a tough standard.
I agree. That was her testimony, and that was her escape valve when pressed on that issue.
But what is your take then on 1204 and the ability of an elector to challenge, let's say, the Obama example, where the 22nd Amendment would prohibit him from serving because it limits a person from serving more than 2 terms as president. So let's say President Obama wants to be on the Democratic Party primary ticket, checks all the boxes, unlike Hassan, checks all the boxes, tenders the statement of intent. Can an elector challenge his qualification under 1204, and if not, why not?
I would say no. First of all, from a broader constitutional preemption justiciability question, Article 2 doesn't quite face the same self-execution issues. The courts are split, but the weight of authority has been, because those cases were litigated, the weight of authority with respect to President Obama, Senator Cruz, and Senator McCain, all of whom were challenged on natural-born citizenship. The weight of authority is that states do not have the authority to be able to consider that. That's
Does it
the
matter
weight.
that most of those were decided after the person was elected into office? Does that matter?
Not in that aspect, Your Honor. It does matter because we would submit, and we have said before, that this court should have never exercised jurisdiction because of the complexity of the issues, the truncated procedures, and the inappropriateness of the 113 in this instance. So I think that was more of a function of the time, and they weren't considered moot because they were capable of repetition. So I don't think that matters, though.
Sorry. What does 1204 do then? What can you challenge under 1204 for?
1204, let me step back. Remember, 1204 mandates a hearing within 5 days of the petition, and it mandates a decision within 48 hours. So, and it specifically refers to Section 113, which requires a duty under the code. So that, with that structure in mind, 1204, the very structure of 1204 contemplates a very limited proceeding. And the limited proceeding is set forth in the substantive provisions of 1204, I believe it's 1 and 3. So, for example, there has to be a certificate from the state party saying that the candidate's a bona fide candidate. The candidate has to be affiliated with a party that had received at least 20% of the vote. The candidate has to fill out a statement of intent. Questions as to exactly what the content of that statement of intent is required. There's no rule or regulation that the Secretary has promulgated. It's merely a form which, according to Hillary Rudy's testimony, never went through the process. It was created by people within the office and reviewed by their legal counsel, and that was it. But those are very limited requirements. And under 113, there is not a duty. So to the question, if I may use that to transition a little bit to the 113 jurisdictional issues, could the Secretary of State simply said, I hereby make the determination, I think it's an obvious knowable fact, as she has said on TV, it's an obvious knowable fact, President Trump engaged in insurrection, therefore I keep him off the ballot. Let's say she said that. Does she have the authority to do that?
I think the answer is no. She admitted she doesn't have the explicit authority to do it.
So
I think the court correctly recognized it.
I apologize, Mr. Gessner. I guess I just keep wondering, well, then what are we supposed to do, right? So there has to be some mechanism for review, doesn't there? And under your interpretation of things, is there really any?
To the extent, the way this would work would be the way Frazier suggested. I didn't disagree. I didn't agree with Frazier, and I don't think you did either, Justice Gabriel. But I think this case proves the correctness of Frazier, although I hate to admit it after 20 years of litigating this very issue. What the person would need to do would be file a declaratory judgment action outside of 113 to enforce the 14th Amendment.
Would the deck action be in federal court where there's a likelihood that the person wouldn't have Article 3 standing?
Funny you ask that.
Yeah.
Because it was brought in this very case.
Oh.
Remember, there were 2 counts in the petition.
Right.
One was a 113/1204, and the other was a deck action. We removed it, staff removal to federal court. The petitioner said, no, you can't do that because we have no concrete or particularized basis. So it has to be in state court. There's no federal jurisdiction. So it gets bounced back to state court. Then what we do is we say, well, you don't get the deck action either because those are the same standards Colorado follows. After which the petitioners say, well, you're wrong, but we're still going to remove it in order to streamline the proceedings, which weren't streamlined because we litigated the entire constitutional issue nonetheless. But the deck action would be the proper approach. The deck action would be the proper approach, and they would be required to meet the standing requirements, as other litigants have across the country, and these other issues in a, at most, preliminary injunction context, but also affording time to properly litigate them.
I guess what I'm looking for ultimately is a meaningful opportunity for review. And that doesn't seem like one, at least in maybe the history of this case demonstrates as much. So are we just stuck, I guess is the question?
No, I would say it's completely a meaningful opportunity to review. And look at Kuhn, okay, Kuhn versus Williams. If you remember, that was a residency issue. This court bounced to there were 2 issues brought. One was a constitutional saying that the residency requirements are unconstitutional. This court bounced it, saying you can't bring a constitutional claim. Appropriate under Frazier. So what did the petitioners do? They immediately went to federal court. In that case, and Judge Blackmun in federal court said, you're right, they're unconstitutional. So there was adequate time for review of that constitutional issue in federal court. That was done under a preliminary injunction context, so they required a heightened standard of review. But that procedure has worked and worked fine.
Let me ask you, Mr. Gussie, you rely a lot on Kuhn and Frazier. Do you not see those as distinguishable from this case? In those cases, there was a 113 action, and there was a 1983 proceeding challenging the constitutionality of the residence requirement. That was a separate claim, not within the 113. Isn't that different than here? You say here the 113 action was a constitutional claim. Do you not see those as different?
No, I don't think this was an independent claim as well. Look, I mean, this was dressed up as a 113 and a 1204 action.
But let me push back on you a little bit, if I may. So if there was a 113 challenging the qualification of, whether you're a citizen born in this country or whether you're 35, I think you'd say that fits within 113. So if this is, and I understand you disagree that this is a qualification here, but let's say hypothetically we disagreed, that would fit within 113. I think the other side would say this was an issue about whether President Trump is qualified.
I think you'd have to look at the nature of the litigation itself. Okay? So I would use 2 or 3 different frameworks. Let's put the shoe on the other foot. Secretary rejects in an administrative basis. President Trump then has to sue. What do we sue under? We would sue under the 14th Amendment, and we would sue under the First Amendment, the Brandenburg Standards, saying he didn't engage in anything that incited violence. I'm sure the Secretary, properly so under Frazier, would say, no, you're challenging governmental action. You're challenging my action under the Constitution. You can't do that under the Election Code. You have to do it in a declaratory judgment action. Now, here it's reversed, but it's the same concept.
Why wouldn't you therefore bring it under 113? I guess, why would you start with a losing argument? I'm confused by that. There are lots of kinds of actions where the primary thing that's litigated isn't the underlying basis for the suit. I think about any kind of malpractice case. The vast majority of a malpractice case might actually be the underlying claim, like a legal malpractice case, the claim that was lost. But it's still a legal malpractice case. It's just that you spend most of your time talking about whether you lost the claim that you could have had. So the fact that a lot of ink was spilled and words were spilled on the Constitution doesn't make it a constitutional claim.
The mere fact, I would agree with that. However, I think this differs, that this was in fact a constitutional claim. This whole thing is about constitutional litigation. There's no, look, the court recognized there's not a duty for the Secretary of State to investigate or consider disqualification under the 14th Amendment. The Secretary of State herself explicitly said there's no explicit
And I don't think
authority.
they're arguing that in the duty part of the language. I think I understand them to be saying if the Secretary were to put President Trump's name on the primary ballot, that would be a wrongful act because the former president, is not qualified to be on the primary ballot. So it's not an argument of dereliction of duty, it's an argument about a wrongful act. And under Kuhn, they're arguing we can look at other evidence that she might not look at.
I think Frazier answers the other wrongful act and rejected that expansive interpretation. And specifically, Frazier said the problem with that is that there's no limiting principle. I say that because I made that argument, and it did not succeed. And I will be honest, I think it's proper looking, because in large part the Secretary of State said these expedited proceedings are wholly inappropriate for something beyond the election code because of the complexity of them and the incompatibility with this. And this is exactly, I think, what happened in this case, where we were denied all discovery, no initial disclosures, no opportunities for depositions, a limited time frame of 6 weeks to prepare our case from nuts to bolts to contend with 400 conclusions within the January 6th report, which became 100, which ultimately became 31. So there were a lot of infirmities in these procedures, and that was first and foremost, I would submit, in the Frazier Court's mind. Justice Gabriel, in his dissent, said, well, that can be and should be resolved with respect to a management order, a case management order in the trial court below. I think that optimism was probably misplaced, as proven by this particular case. So this was, in fact, in substance and in consequence, constitutional litigation. This was not a duty under the election code, which is what 113 requires. The reason why 113 has expedited procedures, the reason why they are appropriate and tolerated and endorsed in the election contest is because they are generally simple, straightforward duties that don't involve complex constitutional litigation.
So is the rule that the Secretary has authority if it's simple and not complex, but doesn't if there isn't? I mean, it's hard to articulate a standard like that.
I think the standard is the constitutional standard. To be sure, a residency requirement like the type that was litigated in Kuhn can be complex. Not complex like this. It's like a constitution with the same the consequences of it.
Complicated is whatever it is.
Well, your court equated it, but the
I heard your answer. I
viewed the president, the appointment clause, of course, there's been a lot of discussion on.
And so fair enough. So what is it does also refer to repeatedly the office of the president and the like.
Office under the United States, officer of the United States.
But when it talks about the president,
Yes,
it describes that as an office.
Correct.
So the president is an officer. What is the president an officer of?
So the, if I can find my notes quick enough, the analysis that has been found is that the president is an officer of, to the extent we have that concept of the Constitution. So an office under the United States is one created by the United States government. An officer of the United States is one that serves the United States government. And there's precedent that says, look, senators, representatives, and the president, they are the government. That's sort of the analysis, the distinction. And look, opposing counsel pointed to the emoluments clause as absurd. How could you possibly believe a president would not be part of the emoluments clause? Well, I would suggest you walk into Mount Vernon, and you will see above the fireplace a full-length portrait of King Louis the 16th that was given to George Washington by the French government. And no one batted an eye. It was never viewed as a violation of the emoluments clause because no one thought that it applied to George Washington. There's also the key to the Bastille that was given by a representative of the French government.
We've got enough on our hands without emoluments, right? So,
but I wanted to point out the structural point that it's all consistent with the president not being part.
Let me just harken back to something that was said by opposing counsel, and that is, maybe we shouldn't be so quick to attribute significance to what the framers did with Article 2, Article 6, given that we're talking about framing and ratification that occurred during the Restoration. So maybe it's part of the puzzle, but is it really all that illuminating when we're talking about 80 years difference, and shouldn't we be looking to other sources given that amount of time?
I think it's very illuminating, Your Honor. I mean, the one thing I think everyone would agree on would be that the framers of the original Constitution, like the drafters of the 14th Amendment, spent lots of time thinking a lot of deep thoughts about the exact language that should be used. And I think we should all assume that those words were chosen with care. And the words in Section 3, in multiple ways, mimic the exact language of the underlying Constitution. Officer of the United States. They use that phrase exactly. They use office under the United States. They don't use officer under the United States. No one ever uses that language. It's office under the United States, officer of the United States. The oath. So here's an important point I would make. Petitioners say, well, they're synonymous, doesn't matter. They really sort of include the same. But if you think about what actually happened with the framers, they have before them a United States Constitution, the original Constitution. The drafters of the 14th Amendment. And there are two oaths. One that clearly applies to the president, and one that clearly applies to appointed officers.
Although, as Justice Marcus pointed out, there's no language under Article 6. It just says swear an oath.
An oath.
There is language. The language says to support. Now, people interpret it differently, but that's the language of the Constitution. And my point is this. The drafters of the 14th Amendment said, what oath am I going to choose? They chose the Article 6 oath. Remember, they had before them choices. They could choose the Article 6 oath. They could choose the Article 6 and the Article 2 oath. They could choose neither oaths. Or they could choose both of them. They chose one, and one only. The one that did not include
The one that covered everybody. I think that's also, it seems to make no sense to me. I'm going to circle back to the absurdity argument that if the purpose of Section 3 was to punish oath breakers, that you would set up a provision that punishes those who break the lesser oath, but exempts persons who break the arguably more serious oath to preserve, protect, and defend. What is the rationale for that type of exclusion?
Is it a lesser oath versus a more stringent oath? I think that's a presumption we're making that may or may not be warranted because there's not much case law defining the two.
So can you make the argument that an oath to support is stronger than an oath to preserve, protect, and defend the Constitution?
Preserve, protect, and defend are specific words, specific actions. Support is a general category and far broader. Support can mean all kinds of things.
Like preserve, protect, and defend.
It can mean that, but it can mean other things. Or it could be viewed as narrower. The preserve, protect, and defend are very strong charges, and support is to help those who preserve and protect.
And so the logical consequence of that, though, is that the president doesn't have a duty to support. I mean, that's your argument, right?
No, my argument is this. My argument is that the drafters chose specific, and the language they chose was language that the underlying United States Constitution treated as separate things. We can argue about whether the underlying Constitution should have treated them as separate things. We can argue about whether functionally they should or should not be separate things, but the drafters of the 14th Amendment made a choice.
I think that what we're asking about is the meaning, and what you're arguing about is the meaning. And what I hear you saying is support is a lesser standard.
No, what I'm saying is this. I'm saying the meaning is that the drafters chose to exclude the United States, the presidency by using specific language. I'm sorry, the president, the officer of the United States. My point is, the drafters made a choice to exclude.
Why?
By choosing the support oath language, which mimics exactly Article 6, which applies to appointed officers, and they did not choose the Article 2, which applies to the president.
And I guess I read a lot of briefing over the last couple of weeks. I saw no rational reason for that type of an exclusion.
The historical record is devoid of that discussion. We can make it up here. We can come up with ideas, just that there's a real paucity of evidence. When you actually analyze the citations made by the petitioners, it comes down to roughly one or maybe two newspaper articles during the entire ratification debates. I would not concede that point, Your Honor. I do not.
Can you come up with a rational basis for excluding either the office of the presidency or someone who swore an oath as a president
I think
from the Section 3 disqualification?
the answer is yes. And I think that the drafters, they rejected McKee's draft. They removed the presidency, the president, and they added presidential electors in. And
I
that was the
understand the
mechanism.
textual argument. I'm trying to understand the basis, the rationale. Why?
I think that is the rational argument.
The rationale, not the rational. With an E, rationale.
I think that is the rationale, Your Honor. I just do. I think that's what we need to accept, is that the framers, the drafters of Section 14 made those choices in that era, and it's not absurd because it worked.
So the choice you're saying is that they chose to include the electors instead of the president?
Yes.
But to accomplish the same purpose, in other words, the electors, if this work does design, would prevent anyone from in that situation from assuming the office. So why go about it indirectly when you could just go about it directly?
I guess we go into a more, I don't want to use the word metaphysical, but a more abstract argument is, if the entire nation chooses someone to be president, can that be an insurrection? Or is that democratic choice? Remember, the president is a little bit different. Everyone in the country has an opportunity, or should have an opportunity to vote for that person.
Go ahead.
I don't think anyone here is suggesting, and I don't take the petitioners to have been arguing that the election of a person as president is an insurrection. I think that what the insurrection might have been is a different question. So I'm not sure where you're going with that argument.
I'm going with the broader context of the president is different, and if everyone in the country chooses a particular person as a president.
So if everyone chose an insurrectionist, look, Jefferson Davis, let's use that example. If Jefferson Davis ran a while ago, and the electors who were not themselves insurrectionists chose to put him into the president.
My 27-year-old kid.
I don't think it goes that far. It's that rule embodied in the text of Section 3. Now, there are plenty of anti-majoritarian measures in the structural constitution, and there are these qualifications. No one argues that. But when we're interpreting Section 3 of the 14th Amendment, and we look at the history behind that, and the context, and the language they used. They used to satisfy the conditions of Section 3, you have to be an office under the United States, you have to hold the office under the United States, and you have to be an officer under the United States, and you have to take an oath. You have to have all four of those items in place. Any one of them, Section 3 does not apply.
Stepping away from Article 3, though, for a second, and sticking with the Constitution, could the Democratic Party put President Obama up on the primary ballot? Could that happen?
I haven't done a full analysis of that particular provision, Your Honor. I'm really sort of focused more on Section 3, but could they do it? Conceivably, I think it's an open question. If you look at the political question analysis of the Article 2 courts, the weight of authority was that states could not
could not prevent that.
If I understand your democratic process argument, that would seem to be the logical conclusion. I'm just trying to make sure I understand the breadth.
The breadth is confined to Section 3, Your Honor.
But stepping away, because you were focused also on the Constitution.
Look, I'm focused on the structural Constitution to look at the language. The officer of the United States is used 4 times in the structural Constitution. And each time it does not apply to the U.S. president.
Oh, go ahead.
I mean, not once does it apply.
No, I know.
Officer of.
You didn't answer my question, but that's okay. I'm not going to, I want to let you use your time the way you want to use your time.
So I feel like
Please feel free to take another run at me, Your Honor. I do want to be responsive. Yes, sir.
I feel like we're going in circles to some extent right now. I'm just wondering if we could shift gears. I was hoping to talk about the First Amendment and Brandenburg. Obviously, you've briefed at length the assertion that President Trump did not advocate violence in his speech on the ellipse, and so the counter-argument to that is that we have to look at context, and they assert that we should, well, the trial court obviously did place a lot of reliance on Professor Simi's testimony and coded language. I'm just wondering if you can give us your perspective on the extent to which precedent allows for that kind of analysis. I struggle with what I see as a lack of precedent on that particular issue, how far context goes. What's your take?
Context plays limited and probably almost no role. Now, this isn't a case, the incitement, and obviously we contest that incitement is part of engage. Happy to address that as well. But this isn't an instance of sort of planning, joint planning or a joint agreement where President Trump had specific conversations of back and forth. That's not what this is about. It's about inciting based on his public speech. That's what it's about.
So in saying that, I apologize for interrupting, but are you saying just look at January 6th and nothing else?
I will look at both, but to meet the imminence standard under the Brandenburg analysis, you have to look at just January 6th. That's really what you have to look at. And if you look at January 6th, his speech said, go peacefully and patriotically. He made 2 tweets followed by a video during the subsequent 3 hours.
But he also said probably 20 times fight.
He said it once, and he said, I was ready for this question.
Oh, okay, go for it.
And what he said is, he talked about that he was unhappy with what happened on January 6th, and people told him not to be involved. And he said, I am, because we have to fight. We have to fight in order to keep our country. He didn't say, and this may be splitting a little bit of hairs, but he actually did tell the crowd, go fight. He said, if we're going to protect, if I'm going to do the right thing, we have to fight. Okay? Now, the thing that Simi testified about in particular was that use of the word fight and the methods and language that President Trump used is perfectly consistent with normal patterns of political discourse. And in fact, we provided evidence that showed that fight like hell, fight like your lives depended on, those various iterations are used commonly throughout political discourse. So,
I'm sorry, finish your thought and then I'll jump in.
So the objective use of the language doesn't shift. I mean, we don't have a President Trump rule where if he says fight like hell, it's violent. And if other politicians, and we included senators and President Biden uses the term fight like hell, it's not an incitement to violence. We still look at the objective standards. I mean, we made an analogy to federal campaign finance law, Justice Roberts, who said intent in an effect test is not appropriate. You look at the objective words that someone uses. And the objective words, he said, go down, I know you are going to march down there peacefully and patriotically. He used 2 tweets saying stay peaceful. And he third made a video that said be peaceful and go home. Now,
I want to let you keep going.
Now the petitioners are going to say, look, those tweets don't matter because he didn't say it right. He didn't tell people to go home. He just said be peaceful. But the objective language is saying be peaceful. And we produced one witness on the stand who said the instructions I got from President Trump were to stay peaceful because he heard the speech. Yes, sir.
So this just keeps reminding me of something I struggled with as I tried to evaluate this particular piece of it, and that is that are we not dealing with clear error review of the trial court's factual findings about those circumstances? And I realize that from your perspective, a lot of those findings were predicated on a report that never should have come into evidence. But setting that to the side for one moment, aren't we, to a large extent, stuck with the trial court's findings, findings that were made by clear and convincing standard, even though you chose not to brief the preponderance of the evidence issue that you outlined in the application? So I'm sort of throwing multiple issues in here, but I don't know that we are in a position to say that there was clear error with respect to her findings of his intents, and what happened that day and what led up to it, including the reliance on Professor Simi's testimony.
Well, I don't think it's clear error to apply the facts to the proper legal standard. And the court used the improper legal standard in determining what is in sight. Look, the facts are relatively uncontroverted with respect to what actually happened, because the petitioners rely entirely upon tweets, videos, and speeches. I mean, that's their case.
But there are inferences that are made, particularly by Professor Simi, about what significance should be attached to things that happened before January 6th, right? So,
and that's a legal standard. And we are saying that the events, the tweets and speeches in the years leading prior is inappropriate under the Brandenburg imminent standard. And that is a legal standard, and they should not be considered. So, and we didn't even dispute the underlying facts. We do, of course, dispute the inferences. And I would note that Professor Simi himself said that he did not address intent at all.
Although the trial court did, right? I mean, she found specific...
And it's clear error for her doing that.
Okay.
I mean, that is clear error in those conclusions. But this court can nonetheless review them because it's the application of facts to the improper legal standard. And the facts are the tweets. Look, the facts are all public tweets, public speech, public videos. And we don't contest any of that, what President Trump said in the evidence that was presented at trial. So I think this court doesn't need to look at the clear error. Because, look, it's not just engagement, insurrection. And let me just talk a moment about insurrection. Justice Gabriel, you talked, I think a couple of folks brought up the different definitions. We have a consistent definition. I think you did as well, Justice. Look, the proponents of liability for Trump used...
Not liability. You said liability for Trump?
Or that Trump should be disqualified, the proponents.
Okay, but we're not, again, this isn't a Section 3 claim where there's any kind of liability.
Yeah, I misspoke, you're right. Okay. There's 2, 4, 6, 7 different definitions. The petitioners, in their complaint, I'm not going to spend time unless you want me to read each one of these, but the petitioners in their complaint advocated one standard. Professor Magliocca advocated a different standard. The court adopted yet a different standard. Bowden-Paulson have had yet a 4th standard. Professor Graber provided a 5th standard. The cited Judge John Kane's grand jury charge, which we don't think has much force, but it has yet another standard. And the Simon Greenleaf treatise that was relied upon has yet another standard. Those are all different standards, 2 of which have been propounded by the petitioners themselves. Now, the petitioners say, it doesn't matter. They all include President Trump. They all include him. But I would suggest that the fact that the actual proponents of this proposition have themselves identified 7 separate and distinct standards, some of which require a public use of force, some of which don't, some of which require a hindrance, some of which don't, some of which apply to the Constitution, execution of the Constitution, some of which don't and apply to the execution of a law.
Why don't you focus, because your time is limited, on the one the district court adopted? I mean, any public use of force or threat of force by a group of people to hinder or prevent the execution of the Constitution. What's wrong with that definition?
Way too broad. I think the petitioners actually admitted that a group of people threatening a mailman and preventing him or her from executing their constitutional duties, because that's one of the constitutional powers that Congress has, would constitute an insurrection.
What if we narrowed it to say, prevent the peaceful transfer of power of the United States government? Would that be an insurrection?
To prevent the peaceful transfer? I don't think so, and I'm not sure, Your Honor. Look, I mean, if you look at historically in the context of how insurrection was used, I mean, it has to be for a substantial duration, not 3 hours. There has to be some geographical scope. There has to be a goal of nullifying all governmental authority in an area.
I guess I'm not sure where you said it has to be, where the temporal provision, where's all that coming from? In Webster's Third New International Dictionary defines it as an act or instance of revolting against civil authority or against an established government. So you've added a whole lot of conditions there. I'm not sure where it came from.
I would urge you, I think probably the best exposition of that was the State Attorney General's briefs and the authority that they provided. Okay, but I think also if you look at sort of the historical record. Now you're going to tell me, Mr. Gesser, you're making it up. And I'm going to say, well, so did the judge. And I'll say, we're all sort of making it up at the end of the day.
Well,
yes.
I just want to jump in on this point of how I don't know that we have to come up with a test that's going to necessarily address all circumstances. I guess the question, at least as to insurrection, setting apart whether President Trump engaged in insurrection, but as to insurrection, why isn't it enough that a violent mob breached the Capitol when Congress was performing a core constitutional function? In some ways, that seems like a poster child for insurrection. Why is that not true?
Well, I think what you're sort of saying is the famous quote. I don't know a definition of it, but I know it when I see it. That we don't have a workable standard. What we think in this instance, it doesn't feel good, and it just seems
Well, it's more
wrong.
than it doesn't feel good. For purposes of this case, what we need to do is figure out whether what happened on January 6th, one of the things we need to do is figure out whether what happened on January 6th constituted an insurrection. We don't need to come up with a definition for all times and all circumstances.
Bingo. That's it right there, because without actually convicting him of insurrection, they can't do this.
Insurrection, rebellion. I think we'd agree that insurrection is typically something less than rebellion.
And I would agree with that in the case, and some of the authorities support it, but it's more than a riot. It's more than a 3-hour riot on one building.
Was that just a riot on January 6th?
I only think it properly characterized that way and not as insurrection. And remember, look, the Constitution, Section 3 says engage in insurrection. It doesn't say in an insurrection. What's the significance of that? I think that it indicates sort of a broader process rather than a singular, limited in scope event. And if you look at the Civil War, that was a broad four-year
That was actually more than an insurrection, wasn't it? I mean, the Civil War.
Yes.
I believe levying war was insurrection is getting at something less than a war.
Likely, yes. Now, there are lots of instances in the ratification debates and the framing debates, and I think the AG's pointed this out in their memo, that insurrection, rebellion, war, treason are oftentimes used interchangeably by the drafters. And in fact, you look at some of the authorities here, the petitioners cite, they'll shift from insurrection in some instances and draw examples from treason or rebellion. So they are used very interchangeably. So we would argue that, sort of on the scale of violence and duration and scope and organization, the events of January 6th were more like a riot and far less than a rebellion. And insurrection is far closer to rebellion than it is riot.
How would you define insurrection?
Part of my whole thesis is that we can't define it, and that's in part why this is a non-justiciable question. But to the extent you push me, which you are, I would say it requires at least multiple considerations that go beyond what we had here. I think the duration has to be longer than 3 hours. I think the geographical scope has to be broader than one building. And you say, well, that was the U.S. Capitol. True. It wasn't the Pentagon. It wasn't. It was a singular node. The goal wasn't to nullify governmental authority and set up an alternative government. The goal, if one assumes the predicate
that President Trump directed the crowd, which we reject, to get Mike Pence, Vice President Pence, to delay the certification. That's not nullification. And I understand it's violent, and I understand it's bad, but we, as I would submit, as lawyers in this process, need to distinguish those gradations because they have meaning. And what I would say is the goals were not as broad as something like the Shays Rebellion or Whiskey Rebellion. The organization, there was very little evidence of a robust command and control structure in that level of organization. The use of force did not involve arms, certainly not the level of arms necessary to overcome.
Let me just jump in there, Mr.
And it wasn't capable of being rebellion. Yes, sir.
But the arms, I mean, you make a legitimate point about, there not being a lot of evidence of arms being taken to the Capitol on January 6th, but there were a lot of makeshift weapons that did a lot of damage. I think at least the petitioners are saying 170 people were injured. That's a lot of violence, right? You'd agree. And irrespective of whether people brought guns and knives to the event, I don't know that we need to, pause too much about that when we have that level of violence. What am I missing?
What you're missing is a riot is consistent with using flagpoles and broken up bike racks as weaponry. An insurrection or rebellion is organized, deadly force that's going to nullify government authority. I think there's a big difference there. And look, I understand that the violence of the Capitol was not acceptable, but I do think that it is our job to apply legal standards and understand the gradations involved and whether or not this truly rises to the level of insurrection.
Well, why don't you talk about engagement? You've only got 3 minutes and 40 seconds, so, and I'll just ask you a question to help move this along, hopefully. My concern, I guess, would be, I understand what the argument you make. Engage doesn't mean incite. Those are different things. A leader of an insurrection usually is not involved, or frequently is not involved in the hand-to-hand fighting. They direct it, they organize it, and then they stand back and they watch it. That would be engagement, I would think, if you had an actual insurrection. So help me understand what engage means.
Well, I think that does. And what that requires is sort of a two-way conversation. Hey, you, sergeant or lieutenant, I'm the general, I'm going to do this, you're going to do that. That's different than public speeches. Now look, I mean, if there were a public speech and someone said, and made an agreement with the other side and say, when I say during my public speech the eagle has landed, then we take action. I would submit that that's engage. But that's a much different instance than incite here. Incite is to sort of arouse these emotions only through public speech. It's a one-way conversation.
So if a leader did a more direct, I want you, and let's make this hypothetical. A leader said, President, I want you to go to the Capitol and I want you to take it over and I want you to ensure that they do not go forward on the Electoral College and use violence if need be. That would be engagement even if the leader doesn't go with them?
Very likely, yes.
Okay.
Very likely, yes. If there is an understanding, an agreement, and not some broad inferential conditioning that Professor Simi testified, I don't think that meets the legal standard. But there has to be very definite sort of meeting of the minds that that's in fact going to happen for it to be engagement. Now, it could still be incitement because it's a direct call for violence, which did not happen here. But there is a difference between the two. They do describe. And I would point out that Congress has treated it as distinct. You know, you look at the Second Confiscation Act in 18 U.S.C. 2383, it says whoever incites, sets on foot, assists, or engages in any rebellion or insurrection. So they treat it as differently. And by the way, if I may say, at the end they say, incitement, sets on foot, assists, they shall be incapable of holding any office under the United States, which indicates that the presidency cannot be barred by mere statutes of Congress. So that's that language, under the United States again. Consistent usage and pattern of that. Let me just sort of end up in my, wrap up in the last minute here. This was constitutional litigation. Had the shoe been on the other foot, had the Secretary taken action, and President Trump would have been required to file a lawsuit,
that would be constitutional litigation as well. And all of the dangers and infirmities that Frazier warned about, that Kuhn recognized, that happened here. This was an inappropriate forum for this. It should have been a declaratory judgment action. They could have fought out the standing issues, and we would have done that appropriately. And that's a pattern that has been followed in Colorado in the past. With that said, if you look at the text and the direct textual application of Section 3, it doesn't mention the president. And every structural piece that we've discussed, the natural and comfortable meaning points towards the president's exclusion. That fits in with the broader fact that it's not enforceable by state courts against a federal official. The court should not have engaged in insurrection. Certainly the January 6th report was deficient. We ask this court affirm the district court below, but also strike the dicta from the decisions beyond that court's jurisdiction. Thank you very much.
Thank you, Mr. Kessler. Mr. Olson, you got about 3 minutes, 46 seconds.
Thank you, Mr. Chief Justice. In short, Trump claims this case is too hard for courts to decide, that the standards of insurrection can't be determined, but that's exactly what courts did and do, and that's exactly what the district court did below. And to the extent there's a dispute between courts that reach these questions, our country has a well-worn mechanism for addressing those inconsistencies. I want to talk briefly about insurrection, the officer, and then end on the Colorado Election Code. Justice Hood, you asked how far context goes. It does a great deal of work. In Claver and Hardware, this court said, or the U.S. Supreme Court, Justice Stevens said very explicitly that evidence of authorization of wrongful conduct in other circumstances was relevant to whether the speech at issue there was within or outside the First Amendment. And because there was no other authorization, no other evidence, they found the speech protected by the First Amendment. Here, the district court made extemporaneous extensive findings that the speech by President Trump on paragraphs 288 to 298 were there's a long pattern of him saying things, seeing violence, praising that violence. He used those exact same words on January 6th.
Is Simi's testimony subject to clear error review? Are those facts that the trial court ended up making based on his testimony subject to anything other than clear error review here?
They're subject to clear error review, but the court didn't just rely on Simi's testimony.
No, I know.
She set forth a number of facts, of statements by Trump himself where there was violence. And in the speech on the lips, there were 20 times he called to fight, which is a literal call to violence. He said that 20 times. It wasn't in the prepared speech. He did that so that people wouldn't know that he was going to call people to march to the Capitol. He was going to incite them to violence. Hess also looks at a rational inference from the import of language. And there's no better evidence of what happened than evidence that Trump didn't object to below. And that was Brad Parscale, his former campaign manager, in real time on January 6th said, "We are seeing, quote, a sitting president call for civil war." That easily meets the incitement standard under the First Amendment. And I was amazed. There's a tweet at 2:24 p.m. on January 6th. Trump never mentioned it in his briefs below, never mentioned it at trial. When he was describing what happened on January 6th today, he ignored the tweet on January 6th at 2:24, which sent the mob into a frenzy. There was unrebutted testimony that poured gasoline on the fire and caused the Capitol to be breached. If this is not incitement, I don't know what is. Secondly, Justice Hood, to your question,
Sure, I guess I can. Ouch. I can chat for a second, just a second here. I've been a busy kid for a couple of days. Come on in. I have been worn out. I don't like this chair. I need to find a new one. So what's going on with you? Say you got a lot going on? You're still here? Oh, there he is. Hello, hello.
Hello.
Ouch. I'm turning that down.
You can hear me, right?
Yeah, I can sure hear you. Yeah,
Sounds
you're
good.
Do this. That way I can hear you, huh? How about that?
Yeah, I got on headphones too right now.
Okay. So you say there's a lot going on, huh?
Yeah, it's going to turn into a big story. But first of all, I want to jog your memory for a minute.
Okay.
I want to apologize for the way that other guy acted. I was chatting with you with that other guy, and I don't know, he didn't act too well towards me either, and I don't know what to say. But
Well, I do have a history, and that's why I'm who I am. I am violently opposed to corruption. I'm violently opposed to a broken system, and that's because I am a victim of both. So they go back 20 years ago to find that what happened. They only tell half the story, and that's what you get.
yeah, and I'm also a victim of pretty heinous corruption, although they didn't throw me in prison, but they did some pretty heavy duty medical damage to me. And because I talked about this with that other guy, he didn't want to ever talk with me again. He told me that I was psychotic, but there's nothing wrong with me.
There's a difference.
I know it's a tough story.
Being psychotic and being driven psychotic. Okay, I mean that's.
And I wasn't even doing anything wrong, actually. I wasn't.
You know, well, I don't know if how long you've been following, but 303 guy that was here in town stalked me with a gun 3 times, approaching me, with words that make someone fight. And the 3rd time he did it, you know what? I decided I'll never have that happen again. I'm either dying today or it'll never happen again, because nobody will ever fuck with me that way. So I'm happy it turned out to be the latter.
Well, and after prayer to God, I've seen the impossible change. So this world is getting so heinous that we follow God, and it'll turn out just like it did in the Bible, that we're delivered,
Well, I'm not entirely innocent. I've done my, share of damage to my karma back in the day, but I more than feel I've made up for it. And unfortunately, it isn't what I was accused of. If it was what I was accused of, I probably would have been settling with that, and just carrying on, But I've never settled.
Exactly. That's right. That's what it does to us. Yep.
Okay. So
and now I've actually.
The government knows how.
And I went after the system now, and they act like kindergartners. I mean, I've called them out on their stuff. I've gotten a hold of some higher ups, and I went and tried to get bonds and stuff. And if you only knew, they act like little kindergartners. They talk funny. They act childish as can
I
be.
can tell you how to get a hold of bonds without having to go through their gatekeeper. You can get FOIA requests this way, a bunch of other things this way. I had to do it in Joliet. That's how I got some police records I wasn't supposed to get.
Yeah, and that blows me away if you can. I've sent out common law requests, 18 USC, 2 whatever, all that crap, and all, to everybody. They all denied me.
You should have 2 cover sheets. All it should be is public notice. It says on it, public notice. All right.
Yeah, so I did a common law request, but I like what you're saying. Public
All
notice,
right,
that sounds nice too.
Okay, we'll write this down. 18 USC 1505.
Yeah, I got it.
And
I got them all.
USC,
Sunshine
okay.
Act. I know.
What you do
I
is
know
you
it all,
put
man.
that-
If you've seen my paperwork, you'd probably fall over backwards. But no,
wouldn't
in
surprise me if
Wisconsin
you've
here,
been
man.
following me for a while. If you've
In
been following
Wisconsin
me, you've
here.
got some information.
In Wisconsin here, they're trying to tell me that the prosecutors don't have to have a bond, and they don't have one. And then I got a
That's
call
yes
from the
and true.
prosecutor's
That-
office.
Wait a minute, that is both a lie and it's true.
Really?
Yes. It's has to do with the Bar Association, not the prosecutor's office. They can have a apprentice represent in the line of operating as an apprentice. Okay, a prosecutor.
You might have hit on something, man,
Now,
because this lady
what
was
you
supposed to
can
be
do-
an assistant DA.
Right. So what you can do in order to avoid that is if there's any jail time at all, then it is a criminal act. Okay, because obviously you can't be in contempt of a contract that has not been determined yet.
Yes.
Okay.
Very good.
So what happens is this. Basically, let me see, where the freak was I? I have been doing so much study recently, but
Me too, man. I'll help you out somehow, I'm sure. I'm actually like full blown white hat nowadays, and a lot more 1,500 talents. You just let me know, man.
well,
All different.
I can use some content. Now, mind
Yeah,
you,
I'll take
if
care of
you
you.
pay attention to my output, what you see in my screen there.
I gotta be a little careful because
because
my eyes are a little busy, but I'll try a little bit if you can just help me out a little bit.
What I'm saying
um,
is the audience cannot see you. It's in order to prevent
Okay.
porn bombs. So if you want to show who you
That's
are,
okay.
so I might recognize your.
I can. I'm trying to cover up, not for you. There we go. I'm not trying to cover up for you, man.
You do look
I'm trying to
familiar.
cover up. Yeah, that guy tore you up, and I didn't really appreciate that. I'm sorry, man. I don't. He tore me up too.
Well, the thing of it is, I mean, that's the waters I live in. But the thing of it is, I've been tore up.
Yeah,
since junior
but this
high.
guy, man.
And they make fun of the fact I marched with the Black Panthers back in 1974, 1975.
Well, that's fine.
Okay, and
Yeah,
when
support
I went back
everybody.
To school, I lost 90% of the people I knew instantly didn't know me, and I found out who the friends I had, and the friends I had asked me, "Why did you do that?" It was real simple. One of the kids I used to live down the street from, their house was burned out from a stake in the yard, and his parents
Yeah,
was
that's
killed.
not good.
His name was Lyncha. So
Oh my.
I mean,
Hey,
I mean,
that
that happens to
prosecutor, her
five
middle
people.
name was Lynch.
Oh, really?
That was her original. Oh, dude, and you know what? There's other weird shit that happened too, man.
That's what I was explaining. Wait a minute. That's what I was explaining.
But
Let me
there's
get
another
back to
one.
that.
I can't remember right now, but
Don't
it's really
distract me. I
psychotic
finally
sounding,
figured
man.
out- I finally remembered, how to do this. What you want to do is you want to make sure that you do not give a waiver to a magistrate.
All right.
Okay? That puts you in the next class. You can't give a waiver to a magistrate. Now, in the federal court, that's a standard procedure. I don't do that.
I'm not sure exactly
When they
what
sit
you're
there and says, well,
saying
we
by
can't
waiver,
progress,
though.
we can't progress because you didn't give a waiver. I was like, I'm not waiving anything.
Yeah, I can't.
Okay.
No contracting over here either. I'm sick of it. It's all deception. Father of lies is Satan, and that's
Well,
how they operate.
What it is if it's not inclusive, it's exclusive. In other words, the driver's license, it excludes everything that it doesn't say. And a motor vehicle, by the way, is an electric vehicle, not a gas-driven vehicle.
Mm,
Did you know
that sounds
Because
kind of.
that's the-
You
that's
know
the
what? You're
definition.
right, man. It's not an engine. It's a motor. I never even thought about that.
Okay.
And then you got an infant as infantry. You know.
Okay, so
So.
the thing, what I'm trying to explain is this word game is exactly what you're in.
Oh, I know.
Okay.
Don't worry.
So when you're looking
I've
at
been
these
taking them on
papers,
front
what
lines,
is
man.
not
Front
inclusive
lines.
is exclusive. So when you put in this any paperwork to the clerk, or if you open a case, what should be on the cover is public notices. One of them being per se, another one persona. Okay, the definitions of, and the accordance to support it. So the very first thing that they come to in that case is what? The public notice. There's no way for them, in order to sit there and avoid an appeal for any little thing they want, actually what you want. And it gives them a heads up. If you sit there and start appealing every decision they make, it's gonna go through.
I see.
See, it's not based on.
So
it's based on how short you can write something. Carl Lentz, if you have you found Carl Lentz yet?
That sounds like something from way back when, but
Well,
I
you
don't.
probably remember the Carl Lentz real estate program.
Oh
Remember that?
yeah. I remember something like that.
Okay,
Maybe,
well,
yeah.
he is much more than that. He tore up, the first thing he did was tear up the mortgages and stuff like that, okay? But the next thing he did was demonstrate his prowess because they tried to take his kids on him. He walked into court literally and got them in order to sit there and say, whose kids? Well, your kids, and you have to take responsibility. Whose kids? Your kids. You mean my kids?
Good.
Yes, correct. My kids, meaning property. Give me my property back. He won that.
That's right. My property. Nice.
And me being the eldest of my bloodline, I can make that same claim for anybody within my family because I am the eldest in my family now.
I see.
How's
Wow.
that
I didn't know that you could do that.
Yes, it's true. Your blood is your property. It's the only proper thing to you.
As long as you don't back down and let them put in. I just dealt with somebody the other day. Actually, I went through the TSA recently, and they kept asking me, are you going to need this type of search or that kind of search? I need to search your balls. Literally, you need to search my balls. I'm like, well, guess what, buddy? I'm not going to, and this is a weak story, but it's really important. My point is to stand up everywhere because we have to. And I know I don't want my balls searched, so I told him, I'm like, I don't want to have it. It's against my consent. He's like, well, you got to do it. Okay, well, if you force me, then there's nothing I can do. He's like, do you want a private search or you want to search here? I'm like, I don't need a private search. He's like, you want a private search? You don't, or you want a public search here? I don't need a private search. Yeah. And he asked me again, you need a private search or you want a public search right here?
Public.
I said, look, man, I'm not gonna. No, because then I'm not consenting to him. I never consented to him. My point is, I don't contract with anybody for anything. You know, just because they have a scanner. This is the USA. This is the USA. I live on this land. I'm indigenous, and I'm interested in protecting the public, but they abused me really badly. So, and then finally the guy gave up. He was trying to give me an offer to contract.
Can I inject here? Honestly, it isn't what we know.
That was my last thing, man.
It isn't what we know. It is what people are prepared to hear. It is not what we know. It is what people are prepared to hear, and that goes for the judge too. You see, you're not dealing with the law. You're dealing with people executing the law, which means that you have a failure even before we get started, so you don't sit there and deliberately oppose these people. And I made this mistake.
Oh, I never
I did
opposed
the
them
most
either. That's a
craftiest
big
thing.
mistake too. Always
I
ask
did
questions.
the most craftiest thing dealing with my driver's license, and it was the same judge I had for a felony. Now, part of my plea agreement was supposed to be to return my driver's license so I could return to work, because I got nailed, okay, by the police after the charges. And the prosecutor didn't come through on it. And I'd been to court twice, and the prosecutor didn't show up on both cases in order to clear my driver's license. I was just sitting there, was like, oh my God, you know. And what wound up happening was I got crafty. I wrote a motion for me to pay those fines, and then a consideration to allow me to pay them over a period of time, or to reduce them to a fine I could pay. And I wrote it from the position of the prosecutor. So when he denied my motion, he had three choices. He could accept my motion, he could dismiss my motion, he could deny my motion. So when he denied my motion...
You stipulated the contract, so you closed the case, right?
When he denied my motion, he denied me to pay the fines.
Huh.
I reversed the wording from the prosecutor's point of view, as if the prosecutor was demanding that I pay these. I demanded that I was able to pay them. Get it? And the judge signed off on it.
No, I get it, man.
Now,
there's a lot of things you can do.
Well, the thing of it is, it was considered to be the most underhanded trick that anyone in the courthouse had ever heard. And yes, I heard about it months later, too. Okay, I had to deal with that
That's
courthouse.
good to know.
But the thing of it is, they thought that was the most underhanded, and some of them patted me on the back, others sit there and scowled at me from across the room. It was fun.
Yeah, because you just walked right into their firing line, and they just fired on themselves.
Yeah,
you know, I was just
yeah.
gonna ask you again, though, man. How do I get these bonds, man? I sent it to everybody in Wisconsin.
Okay, you don't.
They're super crazy out
Well,
there.
first of all, you try not to telegraph exactly what you're doing. You can sit there and say, hey, listen.
Nope,
you know
never
what?
told them.
Well, you did by sending all this stuff out. So let me tell you how to get it. What you do is you go straight to the Secretary of State and request that from a lesser.
Done.
Lesser.
Denied.
No, you can't be denied.
I was denied.
No,
I can FOIA. No, I know I can't. I can't. But I can FOIA the phone call.
Let me tell you how to do it. Okay.
All right.
You do give an identification.
Identify? I don't identify myself ever.
Of course you do. WDRN.
Yeah, that's the Wisconsin. What is it?
Wicked Development Radio Network. You request under a press pass, and that's
all right. Cool.
Okay. Now I can authorize
Thank you.
WBOU. Ah, shoot! I got a phone call. Hold on.
No problem. I can wait.
Hello. 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 What the hell's my phone? Just a second. I'm missing phone calls here.
Yeah. Well, you know, every time something good is happening, there's always this major interruption or the.
Well, at any rate, what you want to do is you want to. Just a second. Hello, hello. I'm doing okay. I had also another call restricted. Was there a team meeting or something I just missed? All right. All righty. I'm on the air right now. Oh, okay. But well, when I seen the restricted, I didn't know if I missed a meeting or not. Now I don't know what the restricted was. All right, later. Speaking of the network, that was John. He's the head of all the hardware stuff. But anyway, what you want to do is you want to FOIA them using a press pass, press credentials. You go ahead and you create a email address to respond to, and handle it under the press. Well, that's who it is. And if they have any question, go back to civil investigation. Make sure that you put that civil investigation in there when you submit it. Underline civil investigation. You see what I'm saying? Can you hear me? Hello? Whoop. Hello? 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 Can you hear me?
Yeah. I can hear you. Can you hear me?
Yeah, I can now.
All right. I don't know, man. It might be easier to talk to you on the phone sometime, but we'll keep trying this for a little bit. So, all right. You said civil. I'm gonna write this civil investigation.
Yes, it's contained in 18 U.S.C. 1505 and or 1512. And here, I can bring it up and read it to you so you understand what it implies.
Oh, this is interesting. I mean, it's a little bit of a different approach. I don't know where God is leading me, but they did some really weird things, having weird people call me, and
this is obstruction of proceedings.
Yeah.
Okay. Now they can obstruct the proceedings before you even file it. Oh, my dog wants out. Just a second. All right, you can go for walks. You better go pee pee and poo poo. Go. All right, whoever with the intent to avoid, evade, prevent, or obstruct compliance in whole or in part with any civil investigative demand duly and properly made under the Antitrust Civil Process Act, which is also FOIA, willfully withholds, misrepresents, removes, or from any place conceals, covers up, destroys, mutilates, alters, or by any other means falsifies any documentary material, answers to written interrogations or oral testimony which is subject to such demands, or attempts to do so, or solicits another to do so, or whoever corruptly, or by threats, or by force, or by any threatening letter or communication influence, obstructions, or impedes endeavors to influence, obstruct, or impede the due and proper administration of the law under which the pending proceeding is to be had before any department or agency of the United States, or the due and proper exercise of power of inquiry under which any inquiry or any investigation has been had by either the House of the committee or the House of any joint committee of Congress. Now, where does it specify or not specify civil investigation? Civil investigation is civil. It's a civil act. Okay? So then let's go to 1512. Now, if you're using Cornell, only thing you have to do is just switch the numbers around at the end. Okay, whoever attempts to kill another person, let's say it's not there. Whoever uses physical force, they have a gun, or a threat of physical force, they have a gun, against any person or attempts to do so with the intent to influence, delay, or prevent the testimony of any person in an official proceeding, cause or induce any person to withhold testimony or withhold a record, document, or other object from an official proceeding, alter, destroy, mutilate, or conceal an object with the intent to impair the integrity or availability of an object for the use of an official proceeding, evade legal process, summoning that person to appear as a witness or produce a record, document, or other object in the official proceeding, or be absent from the official proceeding to which the person has been summoned by legal process, or hinder. Now remember what or means. It's equal magnitude. Hinder, delay, prevent the communication to a law enforcement officer or a judge of the United States information relating to a commission or possible commission of a federal offense or violation of conditions of probation, supervised release, parole, or release pending judicial proceedings. So if they arrest you with the attempt of doing something, then stop you when you give them this and you demand to be taken to a federal judge, you got them. Because they're not the gatekeepers to the federal judge. How's that for a little bit of logic? Anyway, let's see here. It goes on to say, whoever knowingly uses intimidation, threats, or corruptly persuades another or attempts another to engage in or misleading conduct toward a person with the intent to influence, delay, prevent the testimony of any person, withhold testimony, withhold record, document, or other object from an official proceeding. Well, you don't have to declare the official proceeding, and that's still coming up. Alter, destroy, mutilate, conceal, evade legal process, be absent, hinder, delay, prevent communication of law enforcement to a judge, whoever, just a second, almost there. It repeats itself.
You can't hear
several.
me.
Yes, I can.
Oh, you can?
Yes,
so
I can
when
now.
you, okay.
Oops, he disappeared. Anyway, all right. Well, there you are. Good. There we go.
I was pressing too many buttons now because I was trying to look
found
at
what I was
something.
looking for. It took me that long, so it worked out just
Yeah.
perfect. All right. In a prosecution for the offense under this section, it is an affirmative defense as to what the defendant has the burden of proof by preponderance of the evidence that their conduct consisted solely of a lawful conduct and the defendant's sole intention was to encourage, induce, or cause the other person to truthfully testify. For the purposes of this section, an official proceeding need not be pending or about instituted at the time of the offense. Bang. There it is. So you don't have to have a standing case, only the intent to bring a case. And the moment they sit there and try to arrest you in retaliation, especially when you handed them at first contact, before you open their mouth, before you accept a question, before you deny answering a question, you hand them these documents. You're doing a civil investigation. You have as much authority and arrest power that they do. Now, I'll give you one. No, you don't. So listen carefully now. There's only two ways for a police officer to arrest you. There's only two ways for them to search your home. Extraneous circumstances and a warrant. But even in the extraneous circumstances, they better earn the warrant with those circumstances. In the event of arrest, if they do not have a warrant, what authority do they have?
Where can you find that in the law?
I can find it. Well, the problem is this is the standard, and they write inversely. Okay.
I'd like to get a copy
so
of that. I
let me
have pretty much everything.
Let me explain. The way that they arrest you, and you can look it up, because I'll give you the right term to look up, is just that you didn't realize that there was only two types of arrest. The other arrest is a citizen's arrest because they're a witness to the crime. That's the reason why they have to let you go if it's hearsay. Oh. It's a citizen's arrest. They have to witness that crime, remember? So they describe all of the criteria they have to meet to arrest you, which is identical to citizen's arrest. But they don't define that. It is a citizen's arrest. So basically, Flatfoot, okay, in your hometown, USA, can lawfully arrest the president if he sees the president violate the law. End. That's it. That's how you give the governor a speeding ticket. Literally. Okay, so.
Can I ask you about that press pass? Is that your radio station?
No. WBOU is WBOU Communications out of Chicago. WDRN is the network interface between WBOU and streamlife.tube and Revolution Radio
let me
and
see
a
if
half
I
a dozen other places.
I hope I don't lose you. I'll try to.
I can.
Down.
It's a very simple press pass in your claim. Just simply put my telephone number. I think you've already got it at one point.
If you can get it to me,
email me.
I don't have it around.
Email me. My email is so many times out there. I can put it in the text, but how would I know for sure your email is yours?
Mine is God is God, and some more than that. It starts out God is God.
All right.
So.
Basically, what I can do is send you what is required on that, okay, and what quote in order to put on. On one side, you probably have to print it out twice, and then just put the pieces together. You go down and you get a ID holder that has a little cellophane in it, like off of a luggage, you know. But it has to be, you know, they have them at like Ace Hardware and stuff like that for a real fancy badge, okay? And you put these, you know, with the back facing each other. On one side it says, the bearer of this press pass is on assignment for WBOU WDRN. That's the end of the topic right there. You've identified yourself. If you choose to, you can flip it over, and then it has my telephone number as a news desk and your name. So they violated you already. You have to let them violate you. That's all there is to it. Otherwise, you have no complaint. And you don't need to give them warning.
It's a claim.
The warning that you give them, is the documents I told you to print out. You're doing a civil investigation, and then it's compounded by the fact that you are not self-published. Now, a lot of these people don't understand. If you're self-published, you are completely lower class, and a bunch of this may not apply to you. 1512 may not apply to you. Okay, because you are self-published. Anyone can sit there and, you know, mail out letters. Big deal. If someone else publishes your work, then you're networked. It's the same thing as a legacy press.
So then with the press pass, I would send a copy of this or something like that along with the paperwork to get the bond?
Well, you'd identify yourself as a member of the press, okay, and that's where it's coming back to. Example, WDRN, your address, your hometown. Or WDRN general delivery to the whatever post office you go to.
Ah, cool. Yeah, if you can send your email really quick, that'd be cool in the chat. Sorry, but I just can't look through a lot of stuff right now.
If you can,
and then I'll fire you an email. Or I might be able to put mine in there. Let me see.
You see?
Yeah, I can put mine. Here, I got mine in there now.
I got it. Look in the private chat. Or no, look in the regular chat. No.
I sent mine.
I see it. I see it.
Okay. It was pretty easy to, even though I'm doing crap right now.
Well.
Yeah, man, I'll just let you know what basically happened to me almost like in 5 seconds, man. There was an incident where people were putting my life in danger, and they stole my cell phones on top of it. Well, next thing you know, the police come and do shit that's like human rights violation. They won't let me go back to the hospital when I tell them I'm dizzy after blood loss, and then I counted about 120 counts of fraud thanks to my camera. And then they come over January 6th, 2021. They tell me over and over again, you cannot report the failing fire alarm anymore. Fire alarm failed. There was also a fatality recently, just a few months back. They told me over and over again. And the police, they said, you sent an email to the state fire marshal. We can't have that. You can't report that. And move out. Over and over again. Move out. Move out.
How did you test that the fire alarm doesn't work?
I'm not saying that I tested it. What ended up happening, I was running for my life from death, and I don't want to share the whole story, but I'll tell you the fire alarm didn't work. It just didn't work, man. And then when the DA came after me for criminal shit, of course they lied, 120 counts of fraud and a lot more. And then they put down, and Joel sent everybody in the building outside after a fatal fire occurred. You know what really happened, man? They came as sick as Jeffrey Dahmer to threaten me to shut my mouth about that failing fire alarm. And then they put something sick like that in there. And they did shit you'd seen in a POW camp to me. And all that fraud, man, thanks to my camera, I got 120 counts of fraud on there. And they're guilty of misprision of felonies and all kinds of shit. And the DA felon, more misprision of felonies, all kinds of Constitution violations, federal felonies. These are sick fucks. Really sick, man. What's their deal, man?
What is active here, dude? Is there any of
I'll
this
tell you
active?
another thing.
Is any of this still active in court?
Well, I took a DPA, deferred prosecution agreement, because I was scared to death because the DOJ I reported for, I showed them I had perfect evidence of major crime being done by the DA and by the police, and they didn't do shit about it. I called the FBI and everybody, the Secret Service. I sent an affidavit to. I won't even tell you the 45 total ones I did. So yeah, of course I pussied out. It's like, what the hell, dude? So that's gone right now. But they're in so much hot water right now that I asked for a copy of the email sent to the prosecutor.
All right. Do you have
the prosecutor?
You said a lot, but the one question: do you have an open case?
I have a GF file right now against them, and I know that's not.
Do they
really
have
the
an
best
open
thing
case against you?
No, they don't. They have a closed case.
You're on a probation status?
I am not. I'm off of the DPA and off of that probation right now, or it was supposed to be.
Okay, so what you need to do
similar.
is reset everything. You may want to choose in order to take a national status. Now,
yeah, I'm borderline on that. I got a guy who's a perfect expert at that. If you will.
Hold on. Roger Sayers is the international top 50 people you can talk to that speaks English. Okay. At any rate, I've been doing a lot of digging. Some of what even Roger Sayers is presuming, I find it written into law in a loop. Person, citizen, resident, national.
Yeah, it's all, I know. That's all bad words.
No, it's written into a loop, so if you qualify as any one of these things, then you are this thing. Right. Okay? Now, that means that you have all of these other things as dual status. You have all these different dual status. You've never
That's what people don't understand. Yep. You can operate in any jurisdiction,
you've never determined what status that you would fall under. Now,
I can declare it anytime I want to.
You can become a U.S. national, or you can become a state national, where your allegiance is to the state, or you can become an U.S. national, where your allegiance is to the U.S. government.
I do know a lot about this, by the way. I have gone all the way to the deepest details on a lot of this stuff. So,
well, I don't.
Right
like
now,
the
I'm
that's going around right now. There's a couple of opens, and I don't think anyone's actually caught that. I even ran it through ChatGPT. It caught the same opens I did, and I was a little bit surprised if ChatGPT could actually catch it, you know. Because ChatGPT is really dumb. So now you can use it in order to do some primary research. You know, like
this is the dumbest thing I've ever seen. There's a sheriff out here, and he's got an arrow pointing everybody in the emergency lane right now, and he's on the wrong. He's pointing his arrow completely the wrong way. What an idiot, man. Something's wrong in these days, man. I'm sorry, man. It's not the biggest deal. What they did to me was heinous as hell, but this guy's got the arrow going the wrong way. Maybe it's funny to them, just like it's funny to kill people. Those police, they laugh about. There's a story about that, too. Freaking ridiculous.
That doesn't mean they're all like
Dude.
that, man. Some of them
And
will just get along
we got this
gangs,
guy.
you know.
You know what? This guy's driving like shit right here. He's got to drive into somebody's bumper like hell and go nowhere, cutting me off. Anyways, you know, you gotta wonder why the freaking lights are blue on the expressway too. Hint, hint.
You can check your email when you get off.
Yeah, it might be easier to do telephone. Anyways, man, what I was gonna say before, what happened to me, I just barely started digging in. I'll tell you one out of a bunch of them. They had a investigator from the district attorney's office call me and say, "What did you do wrong in the back bedroom, Joel? What'd you do wrong? What'd you do wrong?" Trying to incriminate me all over again or something, because they knew they were in deep shit because there was felonies happening to me that night. They knew it, and then they're like, "Well, I hope you feel better about the district attorney's office. You didn't do anything but talk." And this lady,
Listen,
she sounded like a 2-year-old
understand something.
girl.
Wait a second. You misperceive this completely. It isn't the
I don't know. Be
prosecutor's
careful.
office with loyalty and courage and blah blah blah.
No, there's no loyalty.
You
I'll
are a
agree with
mouse.
that.
You are a
But
mouse.
don't take
you
that.
are a
I'm
mouse.
not
They are a
misunderstanding
lion.
it, though.
And you know how easy it is in order to say, "Hey, man, yeah, I got you for murder. You want to get off of that charge? I'll throw the case. But you have to do a favor
Yeah.
for me." Do you know how easy?
Yes.
The biggest problem
That's
we
all they ever
have
do.
is these people meet these kind of people every single day.
All right, so I didn't have it wrong. There's nothing I
So
didn't understand.
do not
The
underestimate the power of the enemy, dude. The enemy is
the
corruption,
district
but the thing
attorney's
of it is,
office
the
is
battlefield.
heinous.
The battlefield really is, you know, the courtroom, and
Yeah, it's worse than that. It's all heinous, deception, father of lies. But anyway, I just want you to know, man, I did not misunderstand anything. I just want to set the record straight. They are heinous there, okay?
all right. Well, I appreciate that.
They're all heinous. And I got a bunch of other stories, too. I mean, they committed, the cops committed perjury in a courtroom. I told the judge about that, and I told her to stop, and she said everything would count against me because I wouldn't open my mouth and some shit, and then they didn't do anything about the perjury. Dude, I got it all, man. I've been on the front lines, man. I got like 20 other stories. Just
Wow.
keeping it super short. I want their bonds.
I was there when Ferguson blew up and they set fire to the Quick Trip. I was standing right across the street from it. Wasn't recording.
Hey, that's
at
in
the time. I was running at the time.
was it? That was it begins with an M, right? That state was what state
Missouri?
was that in again?
Missouri.
Yeah. Hey, man. I'll tell you something. That you're talking about that from like what more than 4 years ago when there was those big riots.
Dude,
it lit all
4
those
years ago,
buildings on
that
fire,
was
right?
that was when the pipeline blew up. I was there too.
I mean, if you're talking about the one that happened, what was it, like 6 years? I don't know if it was 6 years ago. I can't remember, but I was listening to the police scanner, man. And when they started burning all that stuff down, and what I heard was stuff like this. Check this out. It was like, okay, Advance Auto's on fire. Okay, this building's on fire. And then I heard, all right, everybody move back a block. Oh, everybody move back away this a block. And then all throughout the whole entire thing, I heard this. The guy with the American flag bandana is doing this. The guy with the American flag bandana is doing that. The guy with the American flag bandana is doing this. The guy with the American flag bandana just lit a cop car on fire. I was like, oh my gosh. Wow. You know what I mean?
Yep, I do.
Where did you see that guy? Because, dude, I mean, I'm not about doing anything wrong, but you know what? America's America, and I hate to say it. They are doing heinous stuff to us. They should have learned their lesson in history class. Knock it off. You know, stop abusing the people. We are the highest authority. You know?
Right. No, that's true. We are. But the thing of it
It's
is,
declared-
we are only if we claim it.
Yes, because they get us to twist. They use deception, and they get us to change our mind due to the coercion of the gun-toting morons and all kinds of other things. People don't stand up. People don't realize what you do in that situation. You don't fight them, you don't argue with them, you ask questions, and you don't follow. You know, that's what you got to do. You start fighting with them, yeah, you get into trouble, but you got to do it the right way. Don't contract with these idiots. They're all from Satan.
Well,
I cannot believe it.
Well,
Till now.
the biggest one of the things that studying UFOs and stuff like that, it made me realize, if you were an alien child, how would you know that if you were brought up by humans?
Yeah, you don't know. A dog doesn't know that a human's anything
you wouldn't know
different
it,
than a
right?
dog.
So why would you presume that these people are working for Satan if they don't even know the fact that they're working for Satan? The only thing you can do is address little reason they may have. You can address that as a person. Your first trial is as a person.
I'd like to correct that. Actually, remember that Satan is stated to be the father of lies. They work on pretty much 100% lies. They're all deception. They are using Satan's best tactics. So yeah, whether or not it works this way or that way, they are working for Satan. They are doing the number one thing. Satan will put fear in people. Satan's the father of lies.
They may not know that.
And so, you know what? It's just the way it is. That's possible. And I can agree with that. I just want to let you know, when I say something, it's got to be fully true because they're involved in it so heavily. They are working for Satan. They're the father of lies. It works great. The father of lies, I guess it doesn't get old because they are so successful in hurting the people. And I just look at it. You know, I look at the way that my friend and my other friend took the injection and stuff like that. How hard was it to just say you might lose your job?
We can't talk about that on YouTube. Yeah.
Oh, all right.
Yeah, I've got a lot of stuff on that. Man, I wish I could pull out, but I can't talk about that on YouTube.
And I'm not looking to be anything but vague, but I'm talking about fear, man. You know, it's just even the thought of a maybe fear, you know, and if people are working so hard that, you know, you just let them say maybe you're going to lose out on your income, and people just can't handle it because we're so enslaved. Well, they don't need our taxes. You know, our taxes, all they need to do, if they want money, they'll just print it. Our taxes are just there to oppress us, and obviously they don't go to protecting us because these people are heinous. I mean, it's sick. You know what else they did to me? There was something like a meth lab, and I had to go to the doctor. I was getting sick from the chemicals. And frickin', you know, and this is a very nice neighborhood, by the way. You know, and the landlord screams at me 4 times on the phone, and next thing you know, the fire department comes over and threatens to give me a ticket. And then the health department delayed the whole situation out until the guy was moving out. But they were going to do some investigation, but they had to wait a month and a half for some odd reason to have me write down what happens every day when I told them it's every frickin' night for many hours. Bullshit. You know, I mean, there's some sort of a very funny thing going on between this multimillionaire and his fire alarm and that death, and they have to do sick shit to me and shut my mouth about the fire alarm, and we'll ticket you about the meth lab. Shut your mouth. It's sick, man. Who would ever think that the police are going to come over and the fire department's going to come over and tell you, oh, there's a meth lab that could explode the whole building? Shut your mouth or I'll ticket you. It wasn't exactly that way, but that's what they did to me. I woke up a little too late. It's just sick freaking shit, man. Talking about it. I put my neck on the line telling them the fire alarm didn't work that night. Now I really regret it. But you know what? I'm a hero, and they're a coward. Revelations 21:8. The cowards will be put in the lake of fire. Article 99. Cowards. People who did not protect their fellow man, their people, which the U.S. military has also failed to do to me. The provost marshal refuses to protect. Article 99, you refuse to protect your man, or you act in cowardice in some way, you retreat against the enemy. That's what they did. That's a coward. They were hung at dawn from Article 99. Same thing in the Bible, Revelations 21:8. Cowardice, thrown into a lake of fire. Liars, thrown in a lake of fire. I mean, this is serious stuff, man. And, you know, it caused a lot of damage, a lot of medical damage. It's just, why? What drives them to be this heinous? That's my story.
Right.
Jeez, man. Sick, man. Call the frickin' police. It's just like calling Santa Claus and he goes out and pulls out a gun and starts shooting all the kids. Call the police department, the fire department, tell them that the building can explode, and they sit there and threaten to give you a ticket. Come on, man. Don't even let me go to the frickin' hospital. Come on.
Oh, that's a
and
nice
then 120.
lawsuit. How long ago was this?
2021, January 1st. They gave me a lot of shit because I sent them some pretty badass shit. I got their records where they said that I was harassing them by filing a report to the fire marshal saying that the fire alarm didn't work and that they're refusing to do anything about it. And it's like I'm being treated as if they're tyrants. They said it's borderline harassment. So they admitted to breaking the First Amendment. They admitted to going against redress. They admitted to taking away my freedom of speech. They told me I had to. I shut my mouth. They got a gun. They got a badge. You know, we can always say that that's. Huh?
Are you still living in that same area?
No, we got the hell out of there, but we had to live in an attic with all kinds of shit because we couldn't get an apartment, and I was like kind of newly married. It's really a terrible
it's better
story.
in the basement. You got
No,
an attic, it's better in the
it
basement.
is, but it really is, man. But I just cannot. I haven't even told you that. I'm trying not to take up the airtime. I haven't even told you the damages they did. It was severe medical damage they did, and it's just all the shit. We almost got divorced. It's just, you know, you can only imagine.
Right.
It was all hell on earth, man, and all because these people. It's like I said, call up Santa Claus, and maybe he'll go shoot a bunch of children. It's the same thing, the same example story of me calling up the police, and they're doing all this heinous shit to me in the fire department, both of them. And dude, seriously. I mean, these people, you know, and I tried to save my enemies. I followed God's word. Really hurt, man. Really, really a story, you know.
I hear you.
And this is the world we live in. And since people are listening to me, let me say, after prayer to God, I've seen the impossible change. It is that way nowadays, where a lot of people are going through a lot of shit. I don't care if somebody has cancer or people are in all kinds of biggest trouble. It's really heinous in the world. Volcanoes going off, earthquakes, shit's really hitting. There's something huge happening right now. It's getting really evil all over nature, the way people are acting, crime, everything. Pray to God. I've seen the impossible change. You make the choice. You don't have to listen to me, but I'm sharing my story. After prayer to God, I saw the impossible change. And, you know, it's just like, it's now that, you know, a lot of people are going to, you know, are considering living by faith every day, living by talking to God every day. It's not even just faith. It's just praying to God. That's how this is starting to come now. You know, it's crazy, you know?
Yeah, I do know.
So I have to share that, man, because it's my job. And after I've been doing mission work and feeding the homeless a lot, put my own life in danger, that's how I got treated. That's another funny thing, too, you know? A man like me who's a real hero all the way around, oh my gosh. I don't know what's going to come of this whole thing. But these people, you know, we've seen what the prosecutors do to make people feel bad and cry in court, and you did this nasty thing. I think these people, they may have a good life. Just leave them be. Let them have a good life and be damn straight to hell in God's name. It's going to happen. But if it's not going to be that way, let these people cry like to no end. They deserve to really cry, really see what they did, the heinous, sick things that they did to all society, all those people. And then they made it seem as I was the one to send everybody outside, and after a fatal fire, as if I was the one who set off a fire alarm. And, you know, of course it didn't work for the longest time. And that's how I ended up in the hospital and stuff too. I'm not telling the rest of the story, but anyway, you know, they have to make it seem as if I was the one who sent everybody outside. By the way, nobody went outside. I was out there plenty long enough. Nobody went outside. Plus, that fire alarm was going off for days, like little chirps and shit. They would last like 45 seconds. Nobody gave a shit. Yeah. So, but yeah, man, you know, they had to make it seem as if I was the one who made everybody in the building pretty much go outside after somebody died and burned to a crisp up on the 10th floor. As if I did such a sick thing to that whole building. And then they lied about the fact that there was all kinds of crime, which I happen to have a camera catching all kinds of crime, which they lied about in the police report. 120 counts of fraud. But you know what? They have to make it seem as if nothing happened at all, and it was just some drunk running around on New Year's Eve, having a lollygag of a time and sending everybody outside, making me feel as bad as they can after a fatal fire, a
I'm
nice
still
lady
here.
who's in a
I
wheelchair
have to
burned it.
grab the dog. It's time for food.
That's all right. I'm just letting it out, man. But that's what happened, man. I mean, let them cry, man. Let them feel it. You know what I mean? They deserve to feel that about the fatal fire and all that. But for real. Anyways, man, that's about it, man. Anybody who wants my help, get a hold of me through him. I help a lot of people, 1,500 talents. I don't know if you're going to disconnect this soon or not. But
No, just
there's
stay
God
with
and then
me,
there's me.
Zach.
Oh, you'll be back? All right.
Yeah, I'm just getting the dog some food.
Yeah, I'm just traveling right now, and I just got some stuff to help me get some healthy food.
Got chicken.
So
Yeah, I ate
It's
kind of
kinda-
high on the hog today and yesterday. We had beef sandwiches.
Oh, yeah.
Sliced beef, thin sliced beef.
Wait, are you in Colorado or something
You bet.
like that, or where were you again?
Colorado, Fort Collins.
Yeah, I passed by. Dude,
Really?
that's awesome. I want to go visit WWE, that time clock. I don't know. You know what that is, right?
Not offhand.
Well, I'm a
WWE,
scientist, and I'm a scientist. I like ham radio stuff, and if you turn on shortwave to 5, 10, 15, or 20 megahertz, there's a time clock. It's the most accurate time clock in the world because it's based off like a cesium atom, and it's located in Fort Collins, so they have the most accurate time, and they broadcast it all around the world.
That's over by the Weather Center.
Yeah,
They
and
do
I
some
just, I
strange
mean,
stuff here,
a lot of people.
They launch industrial-sized missiles out of here. They do both ground launch and airplane launches.
Oh wow, that's
Yeah.
cool, man. Yeah, I was passing by, but I was closer to. I was like a half an hour away. You know that main expressway I was passing through to Denver, and I was like, oh shit, man, I forgot to go to WWE, but everyone was like deadly,
Well,
and I don't even know what you can see going near a military base. So
No, we've got some weird stuff here. Here, let me share a video with you. Just a second.
I don't know if I can say something really quick, but we were about 18 minutes away from Loveland, Colorado. You know about that place?
Oh yeah, that's
That?
yeah. I don't even go to
Uh-huh.
the bars there.
That
That's a pretty messed up town.
That town right there is just absolutely known for police abuse like crazy, and it's like love land. You love the land. What do you know? You hate everybody. Love land. Oh yeah, sure. Gosh, those guys are out of control over there. I was about ready to drive over there and prepare to do some First Amendment shit because I'm loaded with shit. You know, I'm like, you know what? Really.
Well, I'll tell you a First Amendment tactic. But if you abuse it, they'll come down on you. If you don't abuse it, you'll wind up being one of the most respected auditors out there. And you wouldn't call yourself an auditor either. I'd call it a compliance
Nope,
check.
I won't. Right. I won't say anything because I actually don't go out there for any intent to do that. I'll go out there for intent to go and look around, but I actually don't cause anything. I'm super sweet and super nice to people, and for some reason they romp on me pretty easily, especially when we meet some opposites
Here, let me
attract,
put
if you
this
will.
in-
So
Can you see your screen okay?
I don't know. Let me see. I gotta go back.
Now this is my old logo. He has to go back. That's not what I meant. That's all right, I guess.
I want to ask you another question though.
Yeah,
So
no,
I'll get those.
stay in here.
I'll get
I
those.
I can go full screen like this, and you can see it. Okay. Go
Yeah,
ahead,
but
ask your question.
I get those bonds, general delivery. It's guaranteed to come, right? I mean, but that prosecutor that handled my case, there was a deputy, and then there was the main prosecutor, and I didn't really see much of him. I think he's some old white-haired dude. So I got him. His name is Brad Warfall, and then there's her original last name was
Well,
Lynch,
if
which
there's
I've
no
seen.
response, then the fact is they don't have anything on file.
Yeah, well, I gave him plenty of.
And
I sent it all over the
I
place.
wouldn't do it general delivery. I would actually let them know and have an anchor with an address. Okay.
Yeah.
They would actually have to violate quite a few laws in order to sit there and cross-reference that to you, and by that time it's too late.
Yeah, but I mean, if they don't have anything, that's like impossible. I mean, you wouldn't believe the paperwork I sent out, you know. But
this here
say,
is what's going on here in town.
I got a bunch of I got a bunch of official responses saying the official responses say that they don't have anything, and they don't have to have anything.
Do you see this?
For their yeah,
this is an orb that's about 2 miles
here
from my house. Shows up, you know, for about a week and then disappears again. Shows up for another week and then disappears again. It just sits there, pretends to be a star.
Really?
Yep.
Huh. I mean, are you zoomed in on it, or is it?
This here is mostly zoomed in on it. I get even closer here. And you can see the swirl of plasma going around it. On the top, it's going clockwise or counterclockwise. On the bottom, it's going clockwise. And you can see it.
Dang, man.
See the black line that goes through it? That's the medium between the North and South poles.
Oh, why does it disappear, reappear? That's kind of funny.
Well, that's plasma. It'll show black where the plasma isn't taking over yet. Plasma has to keep moving. It also has to be continuously fed power. So,
is that freaking Beetlejuice, man?
I wish. No, this shit's.
Yeah.
I mean, this stuff is real, and it's nearby me, and yeah, I'm very cautious on a lot of things.
Yeah, that's
Because
interesting.
I
don't know. Oh, we went to Utah. It's supposed to be the darkest state. Colorado's probably pretty dark too. I don't know if you got some latitude, longitude, or whatever on that.
Oh, it's pretty cool here. I can see the Milky Way stretch across.
Yeah.
You can see the band here.
Oh yeah.
It's about like
definitely.
it was in North Dakota.
Oh, you can see that. We were in Montana. I could see it real heavy, the Milky Way there. Yeah.
Right now we got a cold front moving in, which ain't going to be fun.
But, you know, I got a bunch of official messages coming from the Department of, I don't know, I went way up, man, way up. They officially told me that there are no bonds. I don't think that can be possible, that they can be without a bond.
No, that is possible, and they're still operating illegally, and you don't know what to do as a next step in order to remove them if they don't have a bond.
Well, you know what? You want to know a real funny story, man? I tried to do a bar grievance, and it went straight to the state of Wisconsin, and the state said, I'm going to forward this to the bar. I'm like, get me to the frickin' bar. They blocked me out of the bar, and then they told me, we can't do this, we can't do that. Bullshit. Dude, they took over the whole bar grievance, which I was like, holy shit, dude. I mean, the bar, I should at least be able to do a bar grievance. They get 2 of those, they're gone too. I don't know. I forget what the next step is to have them removed, but I have it written down somewhere. I want to get paid for the damages.
I could try to find it, but the biggest problem you have is what is referred to as standing. What standing do you have in order to challenge their credentials? And that's delicate. You can't sit there and do anything unconventional to their procedure. I'd have to think about it a little bit, but yeah, normally what we're doing is, instead of trying to find out what their bonds, or if they didn't have a bond, what to do about it, what we have done is taken the bonds instead. You see, putting a lien on a bond is nothing more than an act of war. It's a declaration of war, and it means that you're going to court in the most disgusting way possible. You just simply take the bond, there's no retribution. There's no challenge. Unless the insurance company wants to defend them.
Right. Which
So,
they're probably going to give up after this shit.
well,
man.
it's the
I got
same way.
evidence.
You can go into ChatGPT. It's absolutely free, okay? And you can look up how to take a bond. It's the same way you take a contractor bond. You present the evidence. It's over. End.
Yeah, I'm not so worried about that. I mean, that's cool and all, but honestly,
You got to
there might
find
be a
it
couple
first.
tips, but I'm on kind of
They
a,
have to have one, and then you also have to find it.
yeah, I'm on kind of a high level with what to write to them. I'm talking with constitutional law group too and shit, so I got some extra ammo because there's shit that they do wrong every freaking second, by the way.
Oh yeah.
But anyway,
they can't be expected to be perfect in keeping the record, except they depend on the record.
Well, no, I mean, one of the things, man, is every time that they bring a case, it's hearsay because they're not first-hand witnesses and they don't have a first-hand witness. Only under very special instances do they actually have a first-hand witness of somebody who's harmed and damaged them. Otherwise, they're the ones bringing that shit, and it's hearsay because you can't do that. It's just hearsay, man. So every one of them, there's always hearsay. That's one of the things you can go after for. You know?
Right.
Not to explain too much about it because it might not make sense to everybody out there, but I could explain it better because it should be. But, you know, it's, you know, if they're talking about something else that happened, that's hearsay. They have to bring the original man or woman. For me, they charged me and they didn't bring the landlord in or any of those guys to say, hey, Joel did this. And, you know, it's just like, too bad they didn't find out the whole story of what really happened and that the fire alarm doesn't work. Well, they were told about that too. But of course, they have a funny little idea of acting heinous. They seem to torture and abuse people who report things that are there to save human lives, which they did to me. Very powerful. But anyway, you know, all these bonds are coming from Liberty Mutual, it seems. And I think I should be able to get them. You know?
Right.
I mean, I'm at that step right now. If I wanted to take the next step, they gave me official notices that there is no bond. Wisconsin law says they don't have to have a bond. So I got them. You know, I got them.
Well, I got to go ahead and get on to a few things I've got to do. But it was good talking to you, and I hope that you join again.
Well, just stay in touch with me, man, a little bit more privately because I'm not going to say a lot of stuff on the air. This is only the bareliest. You know what I mean? I won't say much.
All right.
You know how it is. You know how it is, man.
Don't call tonight or first thing in the morning. I'm on the air until at least 10 o'clock Central.
I'll send you a text.
Right.
And for everybody listening out there, I do want to say it again. If anyone needs my help, I got a lot of talents and a lot of things that people can't do. Anything. And I will help anybody for free. I've been doing that a long time. That's the type of dude I am. Pretty sick what they did to me, but just don't underestimate it. Could be almost anything, be nearly impossible I help with. And even more than me, I will share with you after prayer to God, I've seen the impossible change. That's what I have to say. That's it.
Huh.
You can get my contact info from this dude. Anyone who needs my help.
You bet.
You can.
I'm sure that you'll join again, and we'll cover this again.
Well, this is rare, man. I gotta be honest with you. I thought this would be impossible. I'm glad I talked with you because it's a much better conversation than last time. I didn't know exactly where you were at, and it seems you are knowledgeable. And it's awesome to have a press pass. I mean, for crying out loud, I got that, you know, and I've already declared press, and I also I signed up for some dumb crap
Well,
on the
again,
internet
there's a
to be,
huge
a
difference
reverend.
between being self-published and being syndicated. Once you join
I'm a reverend.
WGRN, you're syndicated.
Good, and I'm a reverend too, man. It's some dumb bullshit online, but I am. And if anybody comes in and breaks the Fourth Amendment, that's a war crime right there. So, you know, I'm not going to say I don't want to do this. I don't consent. If you force me, I have no choice. Do not search my place. You want to come in? It's a war crime. Put the white flag out. It's a war crime if they come in.
Actually,
You know?
I have something better for you. And
Oh, yeah.
listen, the key to any and all legal action. How do you begin any and all legal action?
I don't know. Legal's the undoing of God's law.
No. How do you enjoin in any legal action, even in God's law? How do you do it?
I'm not sure how to answer that.
You give notice. You give notice.
Uh-huh.
Okay? And that's the reason why those public notices I told you about. Now me, I'd be just simply, instead of going into City Hall, okay, I'd go to the state capitol to the Secretary of State and walk in and make
Yeah,
it.
you know what, man? I've called them on the phone. I've heard of people doing that. Some lady gave a call and she was persisting, and they're like, "We're gonna have a lawyer meet you upstairs." Here in Wisconsin, though, dude, people are extra funny, dude. I called them so many times, they won't even give me their name. That's against the United States Code. And I'm like, yeah, identify, spell your first name, last name. So, I don't think I can do that. You do have to do that. You're aware of the United States Code, are you? That's a crime if you don't. They still won't. In the Secretary of State office, which is the state of Wisconsin, those idiots. There's no state of Wisconsin outside it. So I'm telling you, this is what I'm dealing with. I could tell you so many stories, man. It's that crazy out here, man.
Well,
you know?
Before you do anything, I think that we should tweak it because of some of the details you've covered. But again, like I said, you don't want to be as covert. You don't want to be combative. You want to be as matter of fact as possible and as bland as possible in the request.
Absolutely. I did. All I did was show them the law and say, I need this as the public, you know. That's it, man. That's all I said to them. And I said, I need your indemnity bond, surety, all that stuff, man. Give me your freaking crime insurance policy. Give me the insurance that covers the liability. Yeah, there's Paper Reduction Act, so there's no need to charge me.
Let me explain why going to the Secretary of State was prior to everyone being bombarded, though, a good idea. You see, if you can sneak it into the Secretary of State when the City Hall or city records or county records are inquired, it's not from you. It's from the Secretary of State. They're not going to sit there and redact it or anything. Not at their level. Secretary of State would have to do that, right? And whenever they have on file at the courthouse or otherwise, they're going to have on file at the Secretary of State as well, right? So their matters are too small for the Secretary of State in order to know what the politics is, and the chances of you getting the FOIA request is extremely higher.
All right, I'm totally not comprehending that. Normally I comprehend everything, but
well, let me put it this way. If they're
on
their guard, they're going to scrutinize every word that comes out. If it's from the Secretary of State, or if they have filed it within their own records, the Secretary of State is supposed to have a copy of it.
Mm-hmm. And that makes sense. I just don't see the whole light of this, or how it all, the whole procedure.
The logic
you know?
is this: you ask the Secretary of State for the document from the City Hall or whatever the origin of the document is, that is registered with the Secretary of State. So in the event that the city is not non-responsive, the Secretary of State will take it out of their records. But they'll come up with this great idea themselves. You see what I'm saying? Because you suggested it.
Well, I guess I really don't get it, man.
We're not dealing with law. Now, if you want to go strong arm, we can go strong arm and go get it too. But what I'm saying is it's so much easier in order to get them wrapped up in their regular everyday events than to make any event stand out to them. As soon as an event stands out to them, they look closer.
Uh-huh. Well, you know, I almost in certain paperwork and holding my telephone. I don't see anything wrong with recording, by the way, and I think the Secretary of State is really going to want to try to arrest me if I ask for bonds and walk in there. I don't mind doing it. I just want to have some auditors with me and some other people that are backing me up, which will probably, again, put them on notice that there's cameras everywhere. But I don't know, man. Hidden cameras might be cool, too, but I just, you know, I want to be really careful. And
well, here's a clue. All
been able to
50
do things
states, this is
electronically
true.
fairly well.
Listen to me. As far as a hidden camera and recording is concerned, okay, you cannot publish it, but you can create the recording. Okay, as long as you do not publish it. It needs to be something that you do every day in order to take electronic notes of your life so you can remember things. All right? In the event that you get to court, you did not record with the two-party consent BS. You recorded with your consent, recording your life in your own personal notes that have never been released. Now, when they ask you, can you tell me where you were on the night of the 25th? Well, I would have to refer to my notes. Yes, it's a sucker play. Well, what notes are those? Well, ones I regularly keep. Because you just sit there and fulfilled the hearsay, because now you have records regularly kept. Get it?
Yeah, I get it.
Then we go to the next step. Then we go to the next step. And what kind of notes are they? Oh, they're videos.
Yeah, so
you never released them.
Clarify,
you see, the two-party thing is only for publishing. Is
and
only
I get
in the
it
event
because
of
I get that. I was just about to clarify the same thing. That's if somebody else doesn't consent, but in the public, they are already automatically consented. I don't know how it works in the federal courthouse, but that is actually a public area, and they like to play hard.
No, it's a public area, but it is. You have to define what privacy is, and believe me, I
have to have a locked door.
And I got a guy off. The cops were going to take him downtown because he pissed in the bushes, and I got the guy off by simply saying, Who stuck their nose into your private business, man? Didn't you make an attempt in order to get out of the public view? These are the criteria of exposure.
Nice.
You see what I'm saying? Did you try to achieve privacy? Yeah. Well, in a public area, did you try to achieve privacy? Yes, I did. There's your key to the law right there, because they invaded your privacy and are voyeurs.
Yeah. But if it's public, that's public, and they didn't do anything to show it. You gotta have a locked door. You gotta have some covered.
Well, you want to know? Would you like a reply? Now, I don't know if you've been around pissed off taxpayer. If you remember him years and years ago, I tried to explain to him, and he wouldn't. He refused to listen to me. All you got to do is walk up to a sign. Who is that sign for? When they answer the general public, then you are in the public area.
Interesting. So basically, if they have a sign saying "Do not do this,"
well, you can walk all the way up to that sign. From this point on, you cannot do it. And that was the point, because there was a door that said no photographing, etc., so forth, but it was posted at that door, meaning that past that door, that applied. But in the public lobby, it did not.
So here's what I saw there. I asked the marshals as we walked out. I said, "Where are the signs that show I cannot record?" They said, "Oh, they're in front by the X-ray machine." I looked all over the place. I said,
"Well, I have documents. I have documents. Listen, tell me, sir, does it require a high school diploma to become a deputy here? I mean,
exactly.
I mean, really, does it? Okay, well, that's terrific. You know, with core learning, I understand that they don't give civics anymore, but they do give history class, right? And you have heard of the Ku Klux Klan Act, right? And you did pass the Constitution, because that's a requirement even with core learning, right? Or did you lie getting your high school diploma? Because you're not demonstrating a high school diploma to me, sir. You're not demonstrating you have one. So how can you possibly be a police officer? Give me your supervisor.
So,
thank you.
So they said, and I asked them to say, I was like, show me the signs. They just didn't say a damn thing. But there was no sign in any area. I was holding up my phone.
Of course.
And so there was a door. There was a door I walked in. There was no sign on that door, and there was no sign all the way around the whole freaking building, except for I'm not going back by the X-ray machine because they walked me out, and I didn't see a sign anywhere. I looked everywhere. No freaking sign.
Well,
no sign by the door I walked in where they got
run
pissed.
Back to them. What I would do, honestly, believe them. There is a sign. Sir, someone stole all your signs. Come here, look.
Yeah. But you know what? When I walked in there, I didn't see a sign by that.
Oh, my God, someone stole all your signs, sir. Would you like to know one of the biggest things that I caught? And I have never gotten credit for it. And I've pulled it to a few people's attention. They refuse to understand the significance of it. 18 U.S.C. 245 is the definitions and locations that 18 U.S.C. 241 and 242 apply to, including
those
hotels,
are the good ones.
theaters, marketplaces, right? Okay. So under 245, it says that it is not unlawful to encourage others to join you in a protest. It's at the bottom of it.
Really?
Okay. And anybody interfering with such, okay, is punishable. It's a federal law. And guess who is in charge of upholding Title 18?
Yeah, who is? I want to know because I need to
Title 18
put that
is
on
the
somebody.
FBI. That's what their primary charter is. Not UFOs.
But they won't do shit though. I already sent them a bunch of shit, man.
Huh?
They refuse to help me.
I
They're
know.
just a bunch of bastards.
Just listen. Okay? So you go to Cornell Law University and you look up 18 U.S.C. 245. And then you go over to the FBI, which it is their charter to uphold Title 18.
Wow.
That is their main charter. That was why that agency was created. And guess what? You go to their website, and someone has altered 18 U.S.C. 245, so it does not include the fact that you can encourage others in order to protest with you. So someone has hacked the FBI website. You can go over there now. I bet you it's the same way. Either that or they've removed references to Title 18 completely.
You know, the federal courthouse changed their website just for me, I think, because I emailed them a bunch of shit. And SF-95, case information, FOIAs, all that shit. I threw it all on them because of what they did to me. They did damage me, especially due to my prior PTSD, right?
Right.
And the SF-95 is a good way for them to sue themselves. Well, all of a sudden, off of the front page, it disappeared that you can email them, and then it was buried more. And then, and they tried making up rules. You can't send this, you can't send that. Dude, I'm not under contract with you to do that. I've communicated to you, things that are,
Listen,
things that you have to do.
That's one of the reasons why I carry 18 U.S.C. 1505. Is because they're obstructing an official process. You're there in order to get a FOIA request. You're obstructing my process. The answer would be yes. Are you gatekeeping this process so that only selected people? And ask the question directly. Okay? A lot of people don't realize that you have not quoted the law. They are not on notice. As soon as you properly quote the law and use the proper phrase, okay, then they've just consented to the use of that phrase describing what they are doing. Now, sir.
Yeah, they show intent because they got the ability to.
Can you describe to me one more time how you're abrogating my rights? Oh, yes, sir. I can see what you're saying. I don't quite understand. Can you explain to me one more time how you are abrogating my rights? Why not? And you can say it politely.
Yeah.
Now they're thinking and their script is all screwed up, ain't it? One of the more proud times I had, and I mean I had the lieutenant, I had the chief of police, and I had this duty sergeant, all three of them in the lobby. So when I went down to see Eric Brandt, and we wound up going to the wrong police station. And so when I realized it was at the wrong police station, I went ahead and made a big deal out of it. And I went in and I talked to the desk clerk. And I says, do you know where the fire extinguisher is?
Hold on. Uh-huh.
Okay, and I told him, I'm just doing a compliance check. All right? And he had a big deal. It's like, oh my God, you know, how come you come in here with such authority? All of a sudden, I'm surrounded in the lobby, and I say, hey, listen, I want to see the certification on that fire extinguisher. You guys want to play games? We'll play fucking games. It's absolutely something I can FOIA request, and that means inspect now.
Yeah.
Okay, you should have seen them guys. And the thing of it is, I was quoting the law. I was not sitting there ad-libbing these lines or coming up with new phrases like auditor. Auditor plays in with their game. You say compliance check, there isn't a single police officer who doesn't know what a compliance check is on our car.
Right.
So now you're using phraseology that scares them to death. And the biggest thing, you know, this is 90% bluff. Because there's very few people that can actually carry this through to court. And frankly, I had the opportunity to, but the locals actually stepped up and took care of it for me. The guy who was tormenting me got 20 freaking charges against him. I didn't get one. There he was, you know, for a year trying to get charges against me. I didn't get one. He got 20. What does that tell you?
A minute now, because I'm going the wrong way because my freaking GPS. I'm too scared to use my GPS and shit, man. This is terrible. Dang it, man. I've seen weird signs where, this is bullshit.
At any rate. So yeah, it's been an adventure, dude.
Yeah.
But I mean, like I think you blinked out for a second. What I said is that guy that was trying to torment me and shit and accost me with a gun and trying to start fights and stuff, he got 20 charges against him. I didn't get one after a year of him trying to get charges against me.
Really?
What did that tell you?
What did you do again?
He
not get
was
charges?
harassing me and trying to get charges against me for over a year.
Uh-huh.
Okay. Yeah, him and a guy by the name of Tyrant Bird. 303 and Tyrant Bird. Anyway, for over a year they tried to get charges against me, and what wound up happening, instead of any charges against me, the guy that was, he even drew the gun on me, man. And the same guy that did that wound up with 20 charges against him, ranging from child abuse, animal abuse, illegal firearm, exchange of an illegal firearm, okay, wrist brace he had, but they gave him charges too soon for that. I expect that's gone. But receiving unlicensed weapon and stuff like that, that's serious.
Yeah.
So, you know, I mean, these people will eventually take care of themselves. They come after you with evil intent.
Yeah.
But you have to be, you know, remember to be a mirror. You don't accept any of it. You have to reflect it. Deal with your own problems.
Yeah.
Anyway, that's how I got this finally built. And believe me, today is relief. My phone has not been ringing off the hook, which I'm happy about. But I do have to get off and get a few other things done before nightfall. So it was good talking to you, though.
Yeah, for sure. I'll check my email, man. It's God is God, you know. Anyone needs my help,
I got it. And, I sent you my number. Just don't call tonight. Call tomorrow early afternoon or something.
Yeah. All right. Sounds good.
All right, man. I'll check you then.
I'm going to send you my number, too.
You'll do that when you call me tomorrow.
I can do it by email.
Don't overthink. Just call me tomorrow. Talk to you then.
Well, I'll try to. I'll try to remember, man.
All right. Later. All right. I appreciate everybody that tuned in. It's been a little bit different. Anyway, thank you for tuning in. May your God be with you, folks.